Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content, and today may be the day I earn your subscription. For today's story, we're doing a Supreme Court React and a Supreme Court decision in the case of Whole Women's Health versus Jackson. So this case deals with abortion. This case comes out of Texas. And this is part of Texas's SB 8, which is a bill that was passed by Texas that essentially bans abortion after a rhythm is detected within cells, which might be characterized as a heartbeat, which comes around the 8-week mark, give or take. So there were two cases that came out of Texas, both of which were kind of decided by the Supreme Court today, as a matter of fact. United States versus Texas and Whole Women's Health versus Jackson. They're both related to the same law. It's just a question of who's suing who. So in the United States versus Texas, it was the United States government suing the state of Texas, as the name implies. In the case of Whole Women's Health versus Jackson, it was a whole bunch of private people suing a whole other bunch of people. Some state officials, some private people, some mixed therein, a whole bunch of stuff. So, it's all good stuff there. But anyways, we're going to listen to this oral argument, and we're going to try to read some tea leaves. And then we're going to read a decision from the U.S. Supreme Court in this very case that came down today, as a matter of fact, I believe. Let me just double check. Yep, came down today. So we are going to read a decision in this case. So we're going to do all those things. So let's go ahead and get started with this. Very, very exciting for everyone.
We'll hear argument first this morning in case 21-463, Whole Women's Health versus Jackson. Mr. Herron?
Mr. Chief Justice, and may it please the court, in enacting Senate Bill 8, the Texas legislature not only deliberately prohibited the exercise of a constitutional right recognized by this court, it did everything it could to evade effective judicial protection of that right in federal or state court. Texas delegated enforcement to literally any person anywhere except its own state officials. The only conceivable reason for doing so was to evade federal court review under Ex parte Young. Texas then created special rules applicable only to SB 8 claims that make it all but impossible to protect one's constitutional rights in state court. For a single abortion, the law authorizes limitless suits in all 254 counties and provides that a victory in one has no preclusive effect in any other. Texas incentivized enforcement through awards of at least $10,000 per prohibited abortion against each defendant without any showing of injury, and it added draconian one-sided fees provisions with liability extended even to attorneys themselves. The combined effect is to transform the state courts from a forum for the protection of rights into a mechanism for nullifying them. As Respondent Dixon has said, no rational abortion provider would violate this law. While court clerks are not ordinarily proper defendants, in these circumstances, the principles underlying Ex parte Young authorize federal court relief against clerks. Their docketing of SB 8 suits, which is critical to effectuate Texas's illegal scheme, inflicts Article 3 injury in fact and is redressable by an order barring such docketing. SB 8 is an abortion prohibition, but the issues before this court are far more sweeping. To allow Texas's scheme to stand would provide a roadmap for other states to abrogate any decision of this court with which they disagree. At issue here is nothing less than the supremacy of federal law.
Okay, so that was a whole lot of stuff. And I need to give you a whole lot of background. So in 2 minutes of opening argument in this case, he gave you an entire framework for the case, and it's a lot. It's a lot. So let's discuss what's going on. All right. So as I mentioned, Texas's law, SB 8, is a law that essentially bans abortion after a heartbeat is detected, or what they define as a heartbeat is detected, which occurs at about the 8-week mark in terms of development. Now, there's a whole lot going on in what he just said. First of all, one of the interesting aspects or the notable aspects of the law is its enforcement mechanism. Unlike a typical law, which, would be enforced by state officials of some variety, enforcing the law, prosecutors, attorney general office, state regulatory authority, state health authority, something of that order of magnitude, right? In this case, none of that. Literally, the only people that can't enforce the law are any state official of any variety. No prosecutors, no attorney general, no health official, no regulatory body, nothing. No state official can enforce this law. So who can enforce the law? Everyone else. All the private people can enforce the law. And in all the counties of Texas, anyone can bring this lawsuit against it. They don't have to show particularized standing. Standing, of course, is a concept under both federal and state law. And state law, of course, can define standing any way it wants because state law. So we have to have an entirely separate set of discussions about standing because we're not suing in federal court. Normally, when we talk about standing, we're talking about Article 3 standing. We're talking about suing in federal court. That's normally the context we're talking about. But here, people are suing in state court. So rather than Article 3 standing, we have to talk about state level standing, which of course is open to its entirely separate set of discussions because state law can define standing any way it wants. So one of the questions might be, did it define a standing this particular way? But it's a different set of questions. Another aspect that's different is that there's no preclusive effect from case to case. Another way of saying that is that every case is essentially non-precedential. There's no res judicata. So if someone sues an abortion doctor in a particular case regarding particular facts and they lose, someone else can bring that exact same lawsuit. And someone else and someone else and someone else and someone else. Any number of people, an infinite number of people presumably, can bring that exact same lawsuit concerning the exact same facts with the exact same abortion, the exact same underlying case. This is a concept. There's no estoppel effect from case to case. One case doesn't preclude another. The finding in one case doesn't bind another. There's no res judicata effect. So you can just keep suing forever and ever and ever, and it will bind that one person, but no more than that, until someone wins, until somebody wins. Doesn't matter who. And if no one wins, just people can keep bringing it indefinitely. So the state of Texas barred collateral estoppel. They banned res judicata. They banned preclusive effect. They banned cases from being precedential. Again, state law, right? So entirely set of separate discussions that we'd be talking about if we are originating in federal law cases. So that's one of the things they're talking about. And then the other thing they're talking about is they talk about this case called Ex parte Young, which is a major case in federal law. Ex parte Young says that you can't sue state judges to get them to stop doing stuff. You can't sue in federal court. You can't sue in federal court to get the state judges to do stuff, I should say. You might be able to sue in state court, obviously. That's a whole other set of problems. But Ex parte Young says you can't sue state judges in federal court to get them to stop doing things. You can't get an injunction in a federal court against a state judge. You can get an injunction against an executive official, which is, again, normally how you do this, right? Because normally most states, when they're passing these laws, would, for example, make it the attorney general's responsibility to enforce. So the way you normally do this is by going, a way you would normally do this is by going to federal court and suing the attorney general and say, hey, attorney general, you can't enforce that law because you can bind executive officials. But Ex parte Young says you can't bind state judicial officials. And because the state, again, prevented anyone from enforcing the law except for private parties, Ex parte Young says, wait a second, you can't go to federal court and try to get relief against the judges or by extension, their clerks, or by extension, the clerks that just file stuff in the file room, because that's all part of the judicial branch. So you can't go to federal court and try to get an injunction to stop state courts from doing stuff. That's a non-starter. So that's a whole lot of things that's going on in this case. So Texas, as we've discussed before, very cleverly, tried to create a law that prevented the normal mechanisms of review, right? You can't sue under 42 USC 1983 for acting under color of law because because there's no state officials to bar, right? There's no one acting under color of law. 42 USC 1983 is no good. You can't sue under ex parte Young because you're not trying to because you can't bar the state judicial apparatuses. So you can't sue. So all your normal mechanisms are hosed, and then of course your ability to sue in state court is due to a whole bunch of problems because who do you sue? Because the state officials don't have power to enforce it. So you can sue private people, but how do you sue them in advance? Because how do you know who they are when it can be anybody? So Texas basically tried to think of everything. Whether or not they succeeded or not, I suppose we'll decide when we review the decision that was decided today. But they try to think of everything to prevent the courts from hearing this. And so what this guy who's arguing on behalf of the abortion clinics is arguing is Whole Women's Health is the abortion clinic in question. What he's trying to argue is that this is a case that creates it self-generates. Well, let me not unduly put words in his mouth, but it seems to be what he's suggesting is like, well, this case basically demands some kind of new relief. We need a new doctrine. We need something new that doesn't exist yet to deal with this thing. Ex parte Young. I mean, before ex parte Young existed, there was no ex parte Young, right? Ex parte Young was a case that was decided once. And it's like, so he seems to be arguing we need something new. We need a whole new doctrine. We don't have anything in law that will work. We need something different. We need something new. And in law, when that happens, we call it sui generis, which means self-generating. It generates itself. The case generates its own rationale. So whether or not the decision that we'll decide that came down today does that, that's what he seems to be saying. It's like, this is a whole new thing. We have nothing in law. We have nothing in equity that will let us do what we need to do. They're trying to circumvent the law. They're trying to circumvent equity. We need an entirely new doctrine to deal with this. This case is self-generating its own rationale. This is sui generis, and we need new law to be created to deal with these problems. So that's a lot. That's basically what he said in 2 minutes. I told you it was a lot of things he said in 2 minutes. It's like when you unpack it, it's a lot of things, man. But that's part of the reason I'm here to help. All right, let's listen to some more.
Counsel, you rely on ex parte Young to some extent, but ex parte Young makes clear that federal courts cannot enjoin state judges. So how do you distinguish your case from the express language in ex parte Young?
Your Honor, the language in ex parte Young that I believe you're referring to discusses and specifically allows an injunction against the commencement of the suit. And Your Honor, I think here that supports an injunction against the clerks. It distinguishes between restraining the commencement of a suit versus a suit that after it has already been filed. So I think that language actually supports relief against the clerks here. It's also premised, Your Honor, on there being an executive official who you could enjoin, and here the state has intentionally taken away the executive officials.
But that's what the case was about. It was about enforcing an action against a party. Hence, the case, the focus is on enforcement as opposed to adjudicating that enforcement. And I don't think it really distinguishes it to say, well, this isn't about that. It expressly excludes enjoining a state court.
Well, Your Honor, I think it excludes enjoining the court an action after it has already been filed, but it allows for, it says that there is the power to restrain the commencement of the suit. And I understand, Your Honor, that in that suit it was an injunction against the state official who was commencing the suit, but I don't think that it is. I think the principles underlying ex parte Young, which are to allow a federal forum for the vindication of federal constitutional rights, would support an action here against the clerks to enjoin the commencement of the suit. I also think that that language in Ex parte Young is not about sovereign immunity. It wasn't in the part of the section of the opinion where the court was addressing sovereign immunity. It was addressing a remedy that's available by courts in equity. And here, Section 1983 now provides that remedy, and it expressly allows suits against judges acting in their judicial capacity. But I don't think you need to reach the judges issue, Your Honor, because I think that language does support an injunction and the principles underlying Ex parte Young.
Counsel, I read your complaint, and I thought you only asked for declaratory judgment against the judges and an injunction against the clerks. Did I misread your complaint?
No, you're exactly right, Your Honor. We sought, consistent with the text of Section 1983, we sought declaratory relief against judges and an injunction against the clerks. And I think
so.
So yeah, this is one of the things that they're trying, right, to get around Ex parte Young, because as I sort of mentioned / implied, Ex parte Young only deals with injunction actions. It only deals with enjoining, right? So, well, that's definitely one way to read it. I should suggest, because after Ex parte Young occurred, there was thing done by Congress called the Declaratory Judgment Act, which allows you to get declaratory relief, which allows you to declare things to be true, which would also be binding on courts. It just doesn't like prevent them from doing stuff. It just tells them what the law is, for example. And so he says, well, he seems to be suggesting one of the ways they're trying to get around the problem of Ex parte Young is they're only asking for declaratory relief against the judges, but they're actually asking for injunctive relief, a bar against the clerks. Now, in this situation, what we mean by clerk, because judicial clerk means two very different things. Judicial clerk means a person working for the judge, and it also means a person working in the clerk's office. A judicial clerk that works for a judge is a very prominent position. It's a very notable position. Depending on the relationship between the judge and the clerk can basically be co-judge, depending on the nature of the relationship. It's basically up to the judge how much or how little they want that position to be, but it's a notable position. Then there's the clerk in the mailroom who literally, or the filing room when you go to file cases. The clerk in the filing room literally just looks at it, makes sure that you have the right forms, you pay the fee, and files it. It's a ministerial role. It's non-discretionary. There's no judgment in it. It's like there's not should I file this or not. It's just, do the box, just check, and if not, go no, and if yes, then yes. But there's no judgment, right? It's just file the thing. So they want to get an injunction against the clerks, which to me, in my mind, is just ridiculous as a practical matter. Because how would that even work practically? Suppose you could do that. You would get an injunction against any clerk, a judicial clerk, or a file clerk, I guess we'll call them to distinguish it. We'll call them a file clerk. You get a judgment against any file clerk for filing an SB 8 case. How are they supposed to know if it's an SB 8 case? What are they supposed to do? Are they literally supposed to read them all? I mean, how would that even work practically? So it raises a lot of problems, it seems to me.
Let's go to what the harm is that you're seeking an injunction against the clerks for. Am I understanding correctly that you believe that the way this SB 8 is structured, that what the chilling effect is the very multiplicity of lawsuits that are threatened against you?
Yes, Your Honor, that's exactly right. It is the fact there's a combination of various ways that the state has created special rules applicable only to SB 8 to make state courts a tool that can be used to nullify constitutional rights that have been recognized by this court. And I would point to, I think there are 4 essential components of SB 8 that the legislature created. First is it allows anyone to enforce regardless of any injury. Second, it allows those suits to be brought anywhere in Texas, even for one abortion. So an abortion provider could face suits all across the state for a single abortion multiplied by all the additional abortions that are provided. And then there's no preclusive effect. Even if an abortion provider wins a case about that abortion, they still have to continue to face suit after suit after suit because there's no preclusive effect. It turns the provider or the abortion supporter into a permanent defendant.
Well, counsel,
for 4 years.
I don't want to interrupt your answer to Justice Sotomayor, but just to pick up on a point that you made, and maybe you could clarify this before you finish answering her question if you haven't finished already. Isn't it the case that the Texas Constitution requires a plaintiff to show injury in fact in accordance with the same standard that applies in federal court? One of the first points you made, I think maybe the first point, was that SB 8 allows anybody to sue whether or not that person has suffered any injury. Is that accurate under Texas law?
I think the answer is unclear, but in United States case, in the preliminary injunction hearing, Texas, the lawyer for the state told the district court that Texas law is quite different from federal law on the question of how standing and private interests versus public interest work. They said that at page 49 of the transcript of the preliminary injunction hearing. And Texas
hasn't the Texas Supreme Court said that they follow the same standard as the federal court? Haven't they said that?
They said that recently, but Texas courts are not bound to follow this court's precedents on Article 3. They're not bound to follow.
Of course they're not, but they are bound to follow the state Supreme Court, are they not?
They are, but the Texas Texas Supreme Court has never addressed a law like SB 8. And clearly the legislature thought that it could create standing by creating a cause of action and give everyone an injury. But even if that's correct, even if an injury is required, it wouldn't stop uninjured people from filing suit. And it is the filing of the suit that is the point here. That it is
counsel, the matters that you're talking about now, they're essential to your argument, right? You agree that it would be adequate to have federal court review at the end of the state process, but for the chilling effect that you're talking about, right?
I think not in the way that SB 8 is structured. I mean, if there is review from this court holding that the law is unconstitutional, that would be adequate. But I think that there are a number of reasons.
Review at the end of the day, right? When we have a final judgment from the state judiciary.
But there are a number of reasons that is unlikely to happen. First of all, if you win in the trial court, if the state trial court says that the law is unconstitutional, then getting broader relief depends on your opponents appealing that to the intermediate court, through the Texas Supreme Court, and the proponents of this law are acting very strategically.
Well, that's true in any case, right? I mean, if you get relief in the trial court and your opponent doesn't appeal, there's no real reason for you to seek relief from the Supreme Court, is there?
But in the normal case, if you win that case, if you win, then you don't have to continue litigating that. Here, SB 8 says there is no preclusive effect.
I know you're getting back to the argument that there is a chilling effect. I'm asking for your position in the absence of that. If it's just a regular type of case, surely it's adequate to have federal review at the end of the state court process.
In the normal case, yes, that is correct. I agree with that. That, in a normal tort lawsuit, that is adequate. It is the chilling effect that in this case is created by the combination of delegation of enforcement of a public policy to the general public at large, and there's no preclusive effect, and all of the special rules that are created in order to turn the Texas state courts into a tool that can be used to nullify the exercise.
Even apart from these procedural requirements that you're talking about, I'm wondering if in a defensive posture in state court, the constitutional defense can be fully aired. And I'm wondering that for this reason. The statute says that a defendant may not establish an undue burden, and this is even assuming that the defendant can satisfy third-party standing rules, because the statute says it has to be Craig versus Boren, not the regular abortion third-party standing rules. But it says that a defendant may not establish an undue burden under this section by, and this is D2 in this section, arguing or attempting to demonstrate that an award of relief against other defendants or other potential defendants will impose an undue burden on women seeking an abortion. So I take that to mean that a defendant can only say an award against me would place a substantial obstacle. And that's not the full constitutional holding of either Whole Women's Health or June Medical. It's looking at the law as a whole and its deterrent effect. Do you read that the same way?
I completely agree, Your Honor. Yeah.
So if that's the case, the full constitutional defense cannot be asserted in the defensive posture. Am I right?
I think that's right, Your Honor. That the title of that section that you're referencing is called Limitations on Undue Burden Defense. Clearly, it's not only the procedural rules that the Texas legislature has tried to change the substantive rules that this court applies to protect the.
So does that mean you cannot get full review even on the back end if it goes up through the Texas Supreme Court and up to us the way the statute is structured?
We would have an argument, Your Honor, and we would obviously make the argument that that provision of the Texas law is unconstitutional because it conflicts with this court's precedents in Casey. But Your Honor, it's unclear exactly how the Texas courts would apply that, whether they would follow the undue burden standard. And clearly what the legislature was trying to do was to limit the undue burden defense.
Well, wouldn't they be?
I see a couple people talking about SB8 and it being concerning as it explained. Yeah, I mean, it has problems. I mean, it was created to make abortion very, very difficult to conduct in Texas. That was its obvious purpose, and there's more than enough statements from enough people who were behind SB8 to show that, right? So like, okay, we're going to make sure that you can sue this abortion provider in any county in Texas. Anyone can sue them over the same exact case. There's no preclusive effect, even in the same county, from case to case, right? And so we are making it, we're trying to make it unattractive. We're trying to make it practically unattractive. We're trying to make it so that people won't want to conduct abortions because it will be too expensive. And so it's like, yeah, that's exactly what they were trying to accomplish. So whether or not that's good or bad or not, I will note what I've noted in the past, which is that there's nothing about SB8 that implicitly limits it to abortion. Now, it's not quite as easy as copy and paste. So I don't think you can just strike out the word abortion and write in the word guns and it would work. It would require a little bit more finesse than that. But the underlying philosophy or the underlying technology that I sometimes like to call it would be applicable with some rework in other contexts. So it does create a pragmatic problem for people trying to exercise something that the U.S. Supreme Court has, at least to today, recognized is a right. So that's a little bit what's going on there. So yeah. So hopefully that was helpful in some way.
Wouldn't they be obligated under the Supremacy Clause to apply the federal Constitution as opposed to a provision of a state statute that purports to preclude them from considering a constitutional claim?
They would, Your Honor, but
so then your argument is that they would not follow, that they would not abide by the Constitution.
I'm not suggesting that they would not abide by the Constitution. What I'm saying is that even if you have to prove that undue burden defense in every single case, it is we wouldn't say, and if the state of Texas had passed a law making it a criminal violation to provide an abortion after 6 weeks, that there's no problem because you can simply raise undue burden at trial, at your criminal trial. This court's precedents allow pre-enforcement relief, allow you to come into court and say, I don't need to violate the law in order to first raise my constitutional defenses. I can come into court under Ex parte Young in Section 1983 and seek a ruling that my constitutional rights are being violated.
We have laws that preclude the enforcement of judgments in which process has been denied, where you're not given an opportunity to air your claims. Justice Barrett pointed out to a provision of this law that says you can't present this claim this way, all right? Whether what the judges will do is irrelevant. I thought the essence of your argument was that the law as law is precluding you from using the judicial system as a neutral arbitrator.
That's right, because even if we raise a successful undue burden defense in one case, you have to do it again in case after case after case.
Well, it doesn't really matter. The point is that it's not a neutral arbitrator. It's an enforcer being used as an enforcer.
I agree with that, Your Honor. But Your Honor, here the point is that regardless of the outcome of the case, it is the threat of filing an unlimited number of cases in counties all across the state where there is no preclusive effect, and where the state has even made it so more difficult to get an attorney by making attorneys liable for fees, for the other side's fees.
Mr. Herron?
All of that creates a threat. Yes, Your Honor.
Keep going. Sorry.
I was just going to say that the combination of all of those factors together creates a chilling effect that is preventing the exercise, and that is, under this court's precedence, an irreparable injury.
Can we talk about ex parte Young a little bit? You make the point correctly that usually you can get pre-enforcement review in federal court when it's enforced. A law is enforced by a state prosecutor or state executive official. That's longstanding law. The issue here is different because it's private enforcement in state courts. And that raises a novel issue for us about how to apply ex parte Young. The ex parte Young principle is that those who enforce the law can be enjoined or can be sued in pre-enforcement suits in federal court. But as Justice Thomas points out in the two paragraphs at the top of page 163 of ex parte Young, state courts seem to be carved out from that. So that's the tension. I think you identified it. The principle of ex parte Young versus the language at the top of 163. For me, that's been a real sticking point in trying to sort this out. Now, one answer you didn't give is that subsequent law says that when state courts entertain private civil suits, they enforce state law. One of Shelley versus Kramer being the most prominent landmark example of that. So can you fill in the gaps there and explain to me how we should think about the ex parte Young language in light of how we conceptualize state court enforcement of private civil suits now?
Yes, Your Honor. So I think that the most straightforward way to apply ex parte Young or to allow relief here under ex parte Young is against the clerks, as I've said, because that would stop the commencement of the suits and wouldn't create any of the problems raised in ex parte Young itself about stopping the adjudication.
So I think, sorry to interrupt, but I think Justice Thomas's question was also getting at, though, I take the point, distinguish the judges from the clerks. Are the clerks subsumed within that language in ex parte Young, and you're saying we shouldn't do that? And I just want to hear your answer. Why shouldn't we do that?
That's right. I don't think so, because that language distinguishes between the power to restrain commencement of suits, which I think that language actually supports relief against the clerks, versus whether courts should restrain a case brought before it. Now, which would mean that would refer to the judges here. Now, I do think in subsequent decisions of this court, you're correct. There are instances where the court has recognized in Pulliam, in Mitcham, where relief against state judges, and in fact, Congress recognized in Section 1983, in the text of Section 1983, that judges can be proper defendants, and we brought that declaratory relief.
Well, it's more than just that, frankly, because ex parte Young depends on enforcement. I think that's the key word. Well, it turns out in Shelley versus Kramer, the word enforcement's in there, by my count, 27 times, give or take a couple, to describe what state courts do when they adjudicate private civil suits.
That's right. And in fact, Judge Jackson at a press conference said he's the enforcer of the laws in East Texas. And I think it's clearly correct that when the court issues an injunction, a mandatory injunction, or issues the monetary penalties, what the court is doing is enforcing SB 8.
A judge may be enforcing a state law when the judge renders a decision based on that state law and provides relief based on that state law. But do you think a judge is enforcing a law when the judge merely begins to adjudicate the case?
I think one way of potentially looking at it is that by requiring, yes, in a sense, and one way of looking at it is that by requiring litigants to be in court and requiring them to make filings and appear in court, because here it would be multiplied in courts,
really?
across the state.
Suppose the legislature enacted a statute that said henceforth, people of a certain race may not make any public statement, and someone brings suit under that, the judge begins to enforce that just by entertaining the suit?
I think
Even
in
if
certain
it's
circumstances,
certain that at the end of the case, the judge is going to say, no, this is an unconstitutional statute.
I think in certain circumstances that even in a situation like SB 8, where the point is the filing of the suit and the point is the making you appear in courts all across the state over and over again, making you a permanent defendant, that in these circumstances, yes. I'm sorry, Justice Breyer.
Were you finished? I'm taking up his argument. Look, you say judges, at least in many circumstances, is enforcer. There are 4 billion tort suits in the United States, okay? And probably in 3 billion of them, somebody thinks something's unconstitutional. All right, so can they all sue the judge?
No,
Everybody goes into federal court, sues the judge? And in the state court? All right, what's the difference between this case, where you think he's an enforcer, and 4 billion other cases where you've read their briefs? All right, you understand their argument. What's your response to it?
The response is that under the rule that we are advancing here is that where a state is trying to nullify the exercise of a right, a constitutional right that's been recognized by this court by delegating enforcement to the public and taking away the normal, ordinary executive officials, and then also creating special court rules in order to turn the court system. We're not saying that judges or clerks are intending to do anything here, but it's the rules that have been created by the Texas legislature that turn courts into a weapon that can be used to nullify constitutional rights.
You might appreciate that the idea of suing the judges sort of got our attention. But is there even a case or controversy in such a suit? I understand the position of the plaintiff, exactly what he or she wants. The judge is not necessarily adverse to that. The judge's role is to issue a decision. The idea of someone who's going to decide a question, that person is not automatically adverse to the person who asked the question. And that seems to me to raise a real problem under the case or controversy requirement.
So I think there is a case or controversy. And if I could address the clerks first, that there's adversity in a case or controversy against the clerks, Your Honor, because the clerks are saying they have a duty under state law to docket a petition, to issue summonses, and we are saying that even the initiation of an enforcement proceeding violates constitutional rights and that they should not docket. That is adversity. It doesn't matter whether the clerks agree with the law or want to defend the law.
And the clerk,
I don't really buy this idea that the clerk is the one initiating. The person that's initiating is the person who files the lawsuit. They're the initiator of the lawsuit. The clerk is docketing the lawsuit. They're filing the lawsuit. They're not initiating the lawsuit, right? That's a little bit ridiculous in my view to say that the clerk is the one that's initiating, bringing about this lawsuit. It's like, no, it's the person who's filing this action with the clerk. They're the initiator. The clerk is a middleman. The clerk is a clerk. So this analysis is not really doing that much for me personally. Also, even if that wasn't true, I think they're too closely attenuated, closely attenuated was definitely the wrong phrase of words. They're too closely associated. That's better. Too closely associated with the judges to distinguish. That was one of the questions they were raising earlier. It's like, well, are they just part and parcel of the judge? And it's like, no. And I'm like, yeah, I think they kind of are. They're part of the judicial branch. And to separate the file clerk and the judge is, I think when Ex parte Young was talking about judges, they were talking about kind of the entire judicial apparatus. So it doesn't work on a number of levels for my taste.
Well, a clerk performs a ministerial function. Somebody shows up with a complaint, wants to file a complaint, and assuming the formal requirements are met, the clerk files the complaint. The clerk doesn't have the authority to say, you can't file this complaint because it's a bad complaint. What if the judge, the presiding judge in a particular jurisdiction said, okay, fine, you don't want the clerks filing these things. If anybody shows up with an SB 8 complaint, call me and I'll docket it myself. Then what?
Well, Your Honor, that's why we've asked for declaratory relief against the judges. But I think that
So you got to get to the judges.
Clerks,
this business about the clerks is that?
No, I do think that relief against the clerks, Your Honor, would alleviate most of the harm and would thaw the chill and would allow abortion providers to understand. And in fact, the ministerial nature of their docketing is exactly what makes them a proper defendant here. We know that clerks will docket every SB 8 petition that is brought forward, and the state has encouraged, it has incentivized enforcement by offering $10,000 or more bounties effectively, and by lowering the barriers of entry for people across the state, by allowing anyone to sue without having to show an injury, by allowing them to sue in their home county, and to not have to worry about paying the other side's attorney's fees and even get their own attorney's fees paid. So we know there will be enforcement, and the ministerial act of the clerks docketing is exactly what the state has made the clerks an essential role in this machinery that they have created to nullify constitutional rights that have been recognized by the
Counselor, are you arguing that there's a constitutional right to pre-enforcement review? And if so, how do you reconcile that with Sheldon versus Sill?
So our first argument is actually that Congress created the right in Section 1983.
Assume I don't buy that.
So I think that, yes, there is, and Ex parte Young recognized that in these circumstances where it's not going to be, where the penalties are so severe, and where there is, it's difficult to find someone who is willing to even violate the law for a test case. I think Ex parte Young addressed all of that and said that, in fact, there is a procedural due process violation.
It's okay. I think there is language in Ex parte Young that favors you, and I don't think Thunder Basin assumes that there might be some circumstances in which pre-enforcement review is constitutionally required. In this context, presumably that might happen in state courts. Even if there is some sort of constitutional right to pre-enforcement review, need it be provided by a federal court?
I'm sorry, I missed the last part of the question.
If there is a constitutional right to pre-enforcement review, on your reading of Ex parte Young, does it have to be provided by a federal court?
I think Ex parte Young does support in federal court, yes, in part because state court review in circumstances like in Young and here is inadequate for a number of reasons that I'm happy to get into.
Thank you, counsel. Justice Thomas, anything further? Justice Breyer?
I'd like to just be sure I have this. Your basic point, I take it here at this, as we've discussed it, is this kind of a private lawsuit is not an ordinary tort suit. Okay? So I've tried to write down the reasons, and I want you to add anything I leave out. One, anybody can sue. Well, okay, debatable. Two, anywhere in Texas. Texas is a bigger problem than Rhode Island there. Three, it has no preclusive effect. Jones 1 sues the clinic wins. Jones 2 through 4,000 can sue. 4, the attorney's fees are very heavy. 5, and they don't apply both ways. 5, the penalty of $10,000, et cetera, is heavy. And 6, you are limited, if you are a defendant, as to which kinds of defense you can make in respect to there being an undue burden, which is a problem because most of the undue burden cases speak generally of the effect of the law of the state, not on this particular defendant. Okay? I have 6 that I caught from you. Is there a 7th?
I have 2 more, Your Honor.
Okay.
The first is that damages are not tied to the amount of any harm, which would be normally the case in a tort suit. And the second one is that SB 8 provides for a mandatory injunction if there is a successful claimant to prevent further violations, not to prevent further harm to the claimant. It's not tied to, the mandatory injunction is not tied to the harm.
Thank you.
Justice Alito?
Suppose this happens. A woman shows up at the clerk's office and says, I want to file a pro se complaint against the doctor who performed my abortion because it caused me physical and or emotional harm, and I want to sue under SB 8 because I want actual damages, but I also want the $10,000 in liquidated damages. And you say the clerk should say what?
The clerk should reject the filing of that lawsuit.
Thank you.
Justice Sotomayor?
I presume that any other lawsuit based on common law torts, emotional infliction of harm, breach of contract, medical malpractice, whatever else was available, would still be available to that woman.
If there is a common law tort lawsuit that is not an SB 8 lawsuit, yes.
Contract or otherwise, common law tort or contract.
Yes.
Thank you.
Justice Kagan?
Mr. Herron, if I could turn technical for a minute, should one of your arguments prevail or another argument in support of your position prevail, doesn't matter exactly which argument it is to me, what exact relief are you requesting?
We are requesting an injunction. So we have a pending class certification motion for a defendant class against the clerk. So we would be requesting an injunction against the commencement or the docketing of lawsuits against the clerks across the state of Texas, as well as injunctive relief against the state executive officials for their residual authority to enforce SB 8.
I mean, suppose I think, tell me if I'm wrong on this, that just the procedural morass we've got ourselves into with this extremely unusual law is that we would really be telling the Fifth Circuit, again, if your position prevailed, that the district court had to be allowed to continue with its preliminary injunction ruling. Is that correct? Is that what we would be doing?
I think technically what you would be doing is affirming the district court's denial of the respondent's motion to dismiss, which would then allow us to proceed to our pending preliminary injunction motion and pending summary judgment motion and pending class certification motion.
Yeah. And while the district court does all that, which we would be saying the district court should go do, have you made a motion for interim relief? I mean, I know that there's a motion for interim relief in the United States versus Texas case. But if you were to prevail, we wouldn't even have to rule on the United States versus Texas case. You know, that's very complicated for other reasons. We could just sort of leave that be. But
which seems to be exactly what the Supreme Court, well, we'll see. I mean, but the Supreme Court did dig the U.S. versus Texas case, which is a technical term. They digged U.S. versus Texas, dismissed as improvidently granted. It's one of those great tools the U.S. Supreme Court has because it's the U.S. Supreme Court. Hey, you remember that time we granted certiorari in U.S. versus Texas? No, you don't. We didn't do that. I remember. No, we were wrong. It was our mistake. We should never heard the case. We never heard the case. Go away. Yeah. So U.S. versus Texas was digged. It went poof into the ether, and only a whole woman's health exists with an opinion. Have fun. So I suppose they decided to ignore the complicated issues dealing with the U.S. government, which, fair enough. And we'll see if they are able to resolve the issues dealing with the people versus people in this weird pasture of Texas's Machiavellian-like creation.
But the motion for interim relief is in that case, not in your case. Am I wrong about that, or do you have a motion in your case that would enable interim relief?
We haven't filed such a motion, but I would ask the court now that if it is not going to reinstate the injunction in the United States case, that it issue interim relief now against enforcement because the law is patently unconstitutional. And if these are the correct defendants, then enforcement should flow. So we would ask the court to issue such interim relief.
Thank you, Mr. Herron.
Would the Chief permit me a follow-up on that?
Sure.
Counsel, if we vacate the Fifth Circuit's orders basically staying the district court proceedings, presumably that would vacate its denial of the stay that you had asked from the district court order. We reinstated the district court order, you would have a stay in place, wouldn't you?
So technically there are two stays in place, one that was issued by the district court and one that was issued by the Fifth Circuit. And if you were to vacate those stays in the interim, then we would be able to go back to the district court and ask for an interim relief in the district court.
Well, were you granted a stay of enforcement of the law
Were we
by the
granted-
district court?
We have never gotten to that point, Your Honor.
Ah, okay. Thank you.
We did
I
not
forgot.
get it.
Thank you.
Justice Gorsuch?
I do have a couple of questions. On chilling effect, do you agree that other laws often have chilling effects on the exercise of constitutionally protected rights that can only be challenged defensively?
Not to this extent.
But do you agree that there are laws, defamation laws, gun control laws, rules during the pandemic about the exercise of religion that discourage and chill the exercise of constitutionally protected liberties?
Yes.
And that they can only be challenged after the fact?
I'm not sure that all of those laws could only be challenged after the fact, but there may be some.
Certainly there are certain circumstances where that's true, right?
That's probably correct.
Okay, so it's a line drawing between those cases and your case in your mind. Okay. And then on the relief, am I understanding you correctly that relief against the clerks you think is sufficient for your purposes?
I think that it would go most of the way to getting the relief that we need in order for abortion providers to begin providing. Again, we do think that it is also appropriate for a declaratory judgment against the judges, but I think that the relief against the clerks would.
So if you agreed previously that they're under obligation under state law to file everything that comes in without looking at its contents or judging its contents, right?
Yes, although I think that there are circumstances in which, for example, a judge may direct that a particular person may not file because they have filed too many frivolous lawsuits, for example.
But that's pursuant to a judicial order,
Yes.
but otherwise they're obliged to file everything that comes their way.
Yes.
Okay. And so you say the Constitution overrides that requirement in this case?
Yes, we believe so.
And what about the cases where SB?
It's Legal Mindset joining us from a hotel somewhere.
I forgot my wake-up call today, guys.
Did I hallucinate that conversation, or?
No, no, you were completely right. I was just drinking too much last night.
Oh, well, that's something that's definitely never happened to me, yeah. That's our friend Legal Mindset. Yeah, so we are 34 minutes into this argument so far with Whole Women's Health. The decision also came down today, which I haven't read. So exciting for me.
Very good timing.
Yes, I know. Very good timing. So they digged on U.S. versus Texas, and they came up with some kind of decision, which I haven't read yet. So we'll see what's going on. But so far, we're listening to the people who are representing the abortion clinic, Whole Women's Health, who are basically, in summary, pointing to the procedural complexities of the SB 8 law and how it was designed to evade judicial review and how it's bad, very, very bad, because of all the circumvention and how they need some mechanism to go after it. They seem to be trying to argue it's compatible with Ex parte Young, which I'm not really buying, and I'm not sure they're buying. Slightly better is just sui generis. There wasn't an Ex parte Young before Ex parte Young, right? Someone had to come up with Ex parte Young. So we need a whole new doctrine to deal with whatever this bullshit is. But for some reason, they seem to be avoiding that line of argument. But yeah, I don't know. That's my take. You have anything you want to say as we start getting into some more?
No, I mean this is one that I thought was going to come out on the side of no bueno. That was my initial prediction. So listening to that, I'm listening to that with that ear.
All right, very good. And anytime you want to interrupt or say something, just say please stop or pause or
got it.
Just yell at me.
I'll raise a hand.
It could be constitutionally applied, consistent with Roe and Casey. Should they file those lawsuits? Should they try and determine whether which side of the line they fall on? I mean, post-viability, not for medical reasons, that would meet a Roe and Casey test. Are they supposed to apply Roe and Casey themselves?
I don't think, no, I think that they should be enjoined from docketing any SB 8 lawsuits because SB 8
including constitutional ones.
But I think that the existence of those claims is not chilling the exercise of constitutional rights here. So, but
exactly. But you'd enjoin them anyway.
But I do, yes, because and that's consistent with the relief that has.
And if a clerk goes ahead and dockets a permissible non-chilling petition, a federal judge could find him in contempt and put him in jail, right?
I think that would be there are standards for criminal due process. There are due process standards.
But subject to those due process standards.
Subject to those standards, but I think that those would be extremely difficult, to meet for the most part. And we believe that clerks will follow the injunction in good faith.
Justice Kavanaugh?
A couple follow-ups to Justice Kagan's question. I think you also had a pending TRO in the district court with the preliminary injunction and the class certification. Is that accurate?
Yes.
And then to follow up on the Chief Justice's question, which I think reflects, from my viewpoint, a change in your reply brief, or maybe, I don't want to say change, shift in focus in the reply brief to the clerks from the judges and clerks. And if I'm understanding you correctly, you're saying that ex parte Young principle should apply to both, but the adverseness issue may be more serious with judges, and therefore you focused on the clerks. Is that that's how I read your reply brief, because it was noticeable to me.
I think that's right, Your Honor, that it is easier to say that we are adverse to clerks because the filing of the lawsuits, which is the point here to create the interorum effect and to chill the constitutional rights, is the filing of the lawsuits, and that creates a sharp adversity to the clerks who are just performing their ministerial duty and not adjudicating anything.
Okay, and then last, to follow up on Justice Breyer's question, he mentioned the floodgates issue, which the state has raised. And obviously there are already a lot of ex parte Young suits in federal court to enjoin the usual state laws that are assertedly unconstitutional, but the claim by Texas is that this will increase the load. Give you another chance to respond to that.
I don't think that's correct. This is this is unprecedented. And under the principle that we're advancing, it would not allow suits against clerks to challenge most laws. This is a unique law created because the state has delegated enforcement and has taken away the normal executive officials who would enforce, and has weaponized the state court system into a tool that can be used to abrogate constitutional rights. So this is a unique situation. I think the real danger is if this court does not allow this suit, then that will provide a roadmap for other states to abrogate other rights that have been recognized by this court.
Thank you.
Let me say something here, though, real quick, which is
we're getting to the end of this argument anyway.
Anytime they bring it, and tell me how you feel about this, Kurt, but anytime that somebody says this is unique and special, only in this situation is this ever going to be applied, I'm like, you got to be kidding me. This is the Supreme Court of the United States of America. They only take first of all, they only take cases that they think will apply in multiple circumstances. To say this is a special snowflake, it's only going to be here, that's impossible. That's not why a case is in front of the Supreme Court. It's disingenuous. I think what you need to argue is that the scope will be limited, not that this is unique, right? Because it's not unique, right? There's going to be other people sitting in the same shoes, and there's going to be lawyers, if there are lawyers that exist, that are going to try to force it through that hole. Right, they're going to try to make the square peg in the round hole fit, and sometimes they successfully do that. By arguing just an expansion of the doctrine. Right, you're always going to have an opening.
The ultimate saying on this is that tough cases make bad law, or hard cases make bad law. Either way, this is the reason why. It's like you have a really hard case, you have a really tough case. The law doesn't quite let you do what you want to do, and so the easiest thing to do is be like, hey. The law doesn't quite let me do what I need to do here. I've got this really tough case. Let me just, wish it into existence.
Yep.
And the thing is that all the lawyers in the world scream bloody murder because we work on a precedential system and common law, and we're like, whatever you do, don't lay down that brick there. Because we are in our mind beginning to conjure the possibilities of what the law will look like. And we're all smart enough to know that none of us are even close to the nightmare dystopia that might arise. Our wildest and fanciful dreams don't even begin to approach the dystopia of what might come down the pipe as we build on cases that are hundreds and hundreds of years old. I mean, some of these cases go back as far back as you like to go. Some of them go back further than that, go back to Roman history, go back, so the idea that, it's just going to be for this time only. It's like, this is just, we need it this one time for this one situation. It's like, yeah, bullshit.
That's not how our system works.
We're going to need you to come up with a limiting principle.
Right.
And it's like, well, this is really strange because of how Texas wrote this thing. And, we haven't had anything like this. It's like, yeah, but what happens when someone writes the next closest thing to Texas?
Right.
What
Which
happens
they will.
when they write the next closest thing to that?
Particularly,
where's this going? How? And watch me, good lawyer, squeeze this into the ordinary everyday case, because I'm a good lawyer and I'll figure out a way to do it, because damn it, I'll use that sledgehammer to fix this small thing. Yeah.
Yeah, and it's this area of law is one where there's going to be a lot of litigation, because what they are trying to do, I think, on the abortion side, the tactic is similar to what might be tried on this 2A side. If you're going on both sides of the issues here, you're trying to chip away at different aspects of the right. You're trying to chip away at it from different angles. So yes, of course, this is going to come up again. I mean, there's no way it doesn't come up again.
Yeah, and someone in chat reminded me they weren't using it the example, but they used the magic word slippery slope, and I never really like that argument, period, and I don't like it in this context, because it's one of the most misused fallacies maybe ever, because what slippery slope says is just because A happened, therefore B must happen, right? That's the slippery slope argument. We've gone this far, therefore we must necessarily take the next step.
I mean, to me, I don't conceive it that way on its nose. I don't conceive it as a must. I perceive it as a may.
I think the strong version of it is at least must, is like, we will do this. Yeah. And I'm like, first of all, no. And second of all, if you don't realize that by weakening something, you've made it weaker in the future, it's like, I don't know what to tell you. You've made a hole in the dike, and if you don't realize that weakens the dike, I don't even know where to start with you. It's like, it doesn't necessarily mean the dike will fail, but it's not great. So yeah. So and the other thing too is, like, on a purely pragmatic level, from the government's argument, it's like, I don't know how this is supposed to work for these poor file clerks. It's like, okay, we're going to get an injunction against the file clerks that are going to prevent them from filing any case that deals with SB 8. Query: how are they supposed to be able to determine that? Were they going to read all these things?
They're going to have to hire somebody.
Where are they getting this magical time from? They're
going to have to hire somebody. It's either creating more bureaucracy and administration. I mean, you wonder how these things lead to, a bloated government. It's because you've got to have an FTE, literally an FTE, working on this now, right? Because that's how much time this is going to take, And this happens all the time. When you have a law, there's compliance officers. I worked as a corporate compliance officer. I did a lot of compliance in the government. I mean, there's entire roles that are just dedicated to one specific piece of regulation. But for that regulation, there would not be a job, right? And conceptualize that, guys.
Well, thank God for that, man, because it means all of us lawyers get jobs forever, because they want more regulation, more areas, and man, it's great because we can
be employed.
Things. You want another regulation? No joy. Something else I can specialize in. Yay.
Yep.
Thank you, counsel. General Stone.
Who is this? Is this the Solicitor General of Texas?
I believe so. Yes.
Be just kind of weird, a little strange. I was interested. Women's Health versus Jackson. This is Jude Stone. Who the heck are you? Yeah, it's the Texas Solicitor General. That's interesting. It's just interesting on a technical level because one of the people they sued is the state of Texas, even though the state of Texas has no enforcement power. So it's just slightly funny that the Solicitor General is arguing this, I guess, because it's like, how did we get here? Because this is the weirdest position ever if you're Solicitor General. Because normally as Solicitor General, you're like, yeah, we have the power to enforce this law. And this is the weirdest case ever because you go into Supreme Court and you're like, yeah, I'm a Solicitor General of Texas. I'm here to tell you on behalf of Texas, we have zero power to enforce this law. We have no power. I don't know why I'm here. So this is the weirdest thing ever.
This is a very odd procedural case.
Thank you, Mr. Chief Justice, and may it please the court. Petitioner's pursuit of an injunction suffers from two fundamental problems. First, none of the individuals that petitioner sued are appropriate defendants under well-established Article III and equitable principles. Second, petitioners ask for an expansion of access to the federal courts that only Congress, and not this court, may provide. Petitioners' Article III and equitable problems begin with what they really want, an injunction against SB 8, the law itself. They can't receive that because federal courts don't issue injunctions against laws, but against officials enforcing laws. No Texas executive official enforces SB 8 either, and so no Texas executive official may be enjoined. Petitioners then turn to state court judges and state court clerks, and apparently in this court now narrow their focus to state court clerks. But even they don't suggest that either judges or clerks act unlawfully in the ordinary course by adjudicating a case or receiving a complaint. So petitioners' harms are not fairly traceable to any allegedly unlawful behavior by state court judges or clerks. And this court recognized in Ex parte Young itself that such an injunction would be a violation of the whole scheme of our government. State judges are presumed to faithfully apply federal law and this court's decisions. If they do not, this court may exercise appellate review. That is exactly how federal constitutional defenses are presented and adjudicated all the time. If Congress believes it needs to expand access to the lower federal courts in order to protect petitioners' rights, then that is a matter for Congress, not a basis to alter bedrock doctrines organizing the federal courts. I welcome the court's questions.
Right. So, I mean, like, why not go to Congress? They're the ones that do policy. I seem to remember that in my schoolhouse rock lessons. They're the ones that pass laws and stuff like that. And so I suppose there is something there somewhere in the deep heart of it about the change of the view of the judicial branch, but I'm making that change over the course of like the last 1,000 years at that point, where the judiciary in the long ago, in the far away, just invented a whole bunch of shit out of nowhere, and we kind of frown on that now these days. But that's okay.
Well, I mean, at this point, it's sort of viewed as a. I guess there's a view of it as the second legislative branch, or hey, we're not able to get anything past the legislative branch, so we're just going to ram it through the judiciary, right? Which isn't how you should conceptualize things. They shouldn't be. I mean, we have a basic principle that the judiciary should not be passing or making law. It's really just the the administration of that law and the interpretation of the administration of that law, not creating new law. That's one of the core arguments against Roe. I think policy. I'm sorry. Yeah, and I think one of the issues against Roe was just pragmatic. I believe at the time that Roe was decided, I think 4 states had abortion, and I think it was Washington, New York. I think Alaska was in there for some reason, and Illinois. But I think one of the major problems was it long preceded the change. Like, regardless of how you think of Obergefell, at least at the time Obergefell come around, that most of the states, if not all of them, had some sort of civil partnership law or marriage or something. Right. So I think one of the biggest mistakes from just the legal aspects, which are many, because where are we conjuring this out of the Constitution? I'd still like to know to this day. It's from the penumbra, and then I want to hurt myself. Yeah, it's like no, there's no penumbra. No, I don't acknowledge that doctrine.
Was the word penumbra ever used before, Ro? Because I don't know if it was
I
ever
used
used
it.
in
I
any
used
case.
it when I was playing Magic: The Gathering. There was a card called
Okay.
Penumbra, but that was pretty much it. That's the only time I've ever heard that word, other than
Yeah.
other than that.
So they conjured it out of nowhere, which might have been a problem. I suppose we can debate whether or not they conjured Griswold out of nowhere, which is also a fun discussion. But
God.
or the opposite of that problem, where they nuked the Privileges or Immunities Clause, Section 1 of the 14th Amendment. It was perfectly great. It was wonderful. It was going to do all the things substantive due process wound up doing, and then rather than just the Supreme Court saying, "Hey, we made a mistake, let's undo that."
Mm-hmm.
They said, let's come up with this completely new idea of substantive due process, substantive process, and it makes all my wheels head. I was like, but we have this perfectly functional thing. It's called the Privileges or Immunities Clause. It was supposed to be great.
Mm-hmm.
And we wrote it out of the Constitution, which I don't think the Supreme Court has the power to do, but somehow that happened.
Yeah. It's shocking. It's shocking how far they can spin it. This is very, very interesting. Extremely interesting.
Yeah, that was a little inside baseball geek there for a second.
Yeah.
So yeah.
Mr. Stone, why wouldn't you consider the SB 8 plaintiffs to be sort of a private attorneys general?
That's a good question.
If the attorney general or other state officials don't enforce the law, would it be that unusual to consider them as acting in concert with the state to enforce a state preferred policy?
2 points, Your Honor. First, every tort action undoubtedly advances a state preferred policy. The reason why they're not acting in concert with or cannot be called agents.
Well, but usually when you think of traditional torts, there is a duty, there's an injury to the individual. It's a private matter. There is no requirement here that there be an injury to the plaintiff.
Your Honor, the Texas Supreme Court has followed Article 3 requirements in terms of injury in fact that doesn't need to appear on this face.
So what would that injury be in this under SB 8 if it's an injury in fact?
One example could be akin to the injury suffered in the tort of outrage, where an individual becomes aware of a non-compliant abortion and they suffer the sort of same extreme emotional harm. That would ground an Article 3 injury for purposes of Texas law.
The tort of outrage?
I've never even heard of
You're
that.
allowed to sue someone for being outraged?
Yeah, have you heard of this before, Kurt? Because I've never heard of a tort of outrage at all.
No, I'm definitely suing you though. For being outraged.
We'd sue all of YouTube. It's
for
like
you being late. It's like tort of outrage. Man, Jesus Christ, are we going? How woke are we getting over here, man? Lord have mercy.
I have never been a fan of emotional distress damages, and just like
no, I won't go
line.
quite that far, but I will definitely say that when we're going to this level, it's like but the intentional, IIED in particular, but maybe any IED, I'll agree with you.
Yeah, that's no. See, there's a big difference between IED and NIED, right? And when you're hearing, like, for example, judgments based on people seeing something happen to their pet and being traumatized by it, it's like, okay, how far are we going to go down this? If are you going to give me damages for my favorite body pillow being, or my Hot Wheels collection being crushed, by a trash compactor? I mean, how far are we going to go, right? And to me, it seems like it's a particular political party and political points would love it to go all the way, right? Because they want to be able to litigate based on something that's totally amorphous and is going to be diagnosed every single time by people of their partisan beliefs. Now,
putting aside the whole tort of outrage thing, though, this for me is the best intellectual argument against the whole thing, is that the private individuals are private attorney generals. And I think they're this deflection doesn't really work for me. It's like, well, yeah, it always is enforcing state policy. And Thomas is like, listen, fool, don't play with me.
I love when Thomas speaks. I love it.
Well, Thomas frustrates me sometimes, so he's definitely not by no means my favorite, because sometimes I don't understand the man. But in this case, I agree with him. It's like, look, jackass, when they're trying to remedy their own private harm, and the state says we're giving you a mechanism so we don't have to resort to violence, which is the alternative, presumably. So we'll give you redress in the court so you don't have to, go harm each other personally. That's still a private harm you're trying to redress. And here you're not trying to redress a private harm. Now he's trying to say, and I think he's going to say this, and the briefs definitely said this, is like, well, they're not private attorney generals because they're not subject to control. And I don't buy that argument either. First of all, it doesn't really work for me because the attorney general himself, the actual elected one, is like not subject to any control except for as the law provides. It's like, and so you say, okay, we're going to create the attorney general who's normally the head of all the law. That's kind of his role in life. But we're going to take this little piece away from the attorney general. It's no longer in his domain. And we're going to give it to someone else who is also an attorney general. So we're going to have multiple attorney generals. I can't think of a reason the state can't do that. The state already has multiple Supreme Courts for some reason. They've got one for the criminal law and one for the civil law. They got two different Supreme Courts. Don't ask. It's a Texas thing. But it's like, why can't we have more than one attorney general? This attorney general does with this stuff. This one deals with these things. Okay, great. So we've taken this little piece away and we've given it to literally the entire world. So how's that not just an attorney general too? Because they're not subject to supervision because they're the head of the pyramid in this organizational chart. That doesn't work for me.
Yeah, no, I think I think the top of the org chart should be the one to usually get the suit. I mean, I don't see the point in suing people further down the chain. I think it just muddies the waters, right? I mean, are we going to be enjoining the instead of suing the police chief, we're gonna enjoin like the booking clerk or something?
Oh yeah, no, I think that's definitely true, and then we should definitely look into those things. So yeah.
That would be sufficient to satisfy the Texas Article 3 style screen that addresses some of my friends on the other side's concerns about an unlimited set of lawsuits or that anyone could possibly bring an SB 8 action. Congress passes laws all the time that don't expressly require that individuals show, for example, their own personal injury or traceability or redressability, but nonetheless, this court says those are fundamental requirements of Article 3, and the Texas Supreme Court traces that same requirement to its own constitutional analog, the open courts provision.
But I forgive me, but I don't recall an outrage injury. What would that be? You said extreme outrage. That would be the injury.
Well, the injury would be akin to the one suffered in a tort of outrage, where a person witnesses something that essentially they find to be so extreme and outrageous, cause them extreme moral or otherwise psychological harm. That's
Give me an example of that.
An individual discovers that a close friend of theirs who they'd spoken with about pro-life issues and about abortion has chosen instead to have a late-term abortion in violation of SB 8, and they were very invested in basically in that child's upbringing, the child's coming into being, to the extent to which there's going to have to be a tighter nexus or what's a sufficient injury, in fact, is going to be something that the Texas courts have to develop in the first instance.
Again, this fictional tort, and he's giving this example, and this tort is not convincing me on the wisdom of it. Oh, I was planning on being really invested in this child's life, man, and you had a late-term abortion, and that's outrageous, and I want to sue you for the outrage. What bullshit is this?
Yeah, that's garbage. That's absolute garbage. Sorry. I mean, that just opens it way too far up. I mean, who's going to be able to sue? Their potential future kindergarten teacher. You know what I mean? Who has standing?
I'm going to have to move out of Texas rapidly, man. Jesus Lord, I didn't realize what kind of exposure I was opening myself to. Utah, here I come.
Yeah. So says
and
the
of course,
father.
there's going to be some tether between a real world, not just an offense, but sort of grievous offense that we understand underlies IIED as a tort, and still nonetheless has a real world harm.
Thank you.
I'd like that. I was just going to ask, assume that the bounty is not $10,000, but $1 million. Do you think in that case the chill on the conduct at issue here would be sufficient to allow federal court review prior to the end of the state court process?
No, Your Honor, because that wouldn't affect either the Article 3 or sovereign immunity problems inherent in this case. Undoubtedly, it would increase the chill the same way that individuals who are exercising either protected or arguably protected conduct in a host.
But as I understand it, the only way in which you get federal court review is, of course, for somebody to take action that violates the state law and then be sued under the law and then have the opportunity to raise their defense in federal court eventually. And you're saying that somebody is going to undertake that activity even though they're going to be subject to suit for $1 million repetitively, and because that doesn't exercise a chilling effect?
That's not what I'm saying at all, Your Honor. What I'm saying is it doesn't expand access to the federal courts. There is still pre-enforcement review, I might note. There are currently 14 pre-enforcement review challenges pending in a multi-district litigation in Travis County State Court. So to speak to specifically your concern about federal court pre-enforcement access, no, that wouldn't change the Article 3 or sovereign immunity doctrines in play here. And that might very well be a reason why Congress could be moved to expand access to the federal courts, either through the ordinary course or by using their Section 5 powers under the 14th Amendment. But even if the amount of the sanction, again, I agree with you, $1 million would be tremendous. We could increase it further. No number would suddenly cause the federal courts to become more open.
Section 5 of the 14th Amendment, it's slightly disturbing when the state solicitor general is like, let's Congress use Section 5 of the 14th Amendment. So Section 5 of the 14th Amendment is the enforcement provision. It says Congress basically has the power to make law to enforce the rest of the 14th Amendment. And thank God, at least, that it has been relatively narrowly construed as I think proper to its own terms, and doesn't allow things to do outside this. But he seems to be arguing, if I'm not misunderstanding him, for a much wider Section 5 power. Maybe I'm misconstruing him, or maybe my skepticism hat is on, but tell me I'm an idiot and we can move on.
No. I'm still trying to wrap my head around that concept as well. I'm not sure I completely understand the argument, to be frank. It comes from being Section 5 power. Yeah, no, I don't think you're off base here, Kurt.
Okay.
It's not a question of the federal courts being more open. It's a question of anybody having the capacity or ability to go to the federal court, because nobody is going to risk violating the statute because they'll be subject to suit for $1 million. That takes a lot of fortitude to undertake the prohibited conduct in that case. And under the system, it is only by undertaking the prohibited conduct that you can get into federal court.
Well, Your Honor, individuals, again, to the extent that we're dealing with the sorts of very high stakes, prohibited conduct, fines, sanctions, et cetera, I might add this is specifically a damages action. It is capped at much less than that. That is a significant difference.
My question is what we call a hypothetical.
Of course, Mr. Chief Justice.
Wow.
Nonetheless, an individual facing extreme sanctions still nonetheless often has to go.
Is it law-splaining when it's the Chief Justice of the United States splaining it to you?
I think that's the ultimate law-splain, is when the Chief Justice is telling you what a hypothetical is.
I just got mansplained. I just got judge-splained by the Chief Justice. Oh, that's what we call hypothetical. Oh, is it now? Oh, okay, thanks for clearing that up.
First time I've ever heard one as a lawyer.
Through state court systems to vindicate their federal rights. Individuals are charged with possessions of firearms in states like Illinois and New York, and they face multiple-year incarceration stints as a possibility of trying to exercise their Second Amendment rights. It is, in fact, the case that constitutional rights are litigated right now with very severe potential sanctions for going through the state courts and with no ability to go to the federal courts before essentially that pre-criminal process ends.
Why does the SB 8 allow plaintiffs suing abortion providers to sue anywhere in the state? That's not the normal way venue works in Texas, is it?
It's not, Your Honor, and undoubtedly there are a handful of individual procedural rules inherent to SB 8 that are designed to favor this cause of action, the same way that there are some designed to favor causes of action like bringing a suit under the antitrust laws or under 1983. Happy to stipulate to that.
Now, from the federal level, who cares? Because it's state law, right? If we're talking about state standing, if we're talking about state venue, if we're talking about state res judicata, state collateral estoppel, state issues, it's like, why are you even asking the question? It's like, oh, venues anywhere. Isn't that abnormal? And my response is, sure. What of it?
Yeah, you're not changing federal venue law. You're literally. Why do you care if in state court it's in Houston or in Austin? Like, I'm not getting that argument either. I mean, some of these arguments, it's like, why? Is there some equity argument here?
They raise these questions when they're talking about state level effects. Like, oh, there's no preclusive effect. There's no estoppel. You can sue. You can literally sue in all 250 counties of Texas on the same cause of action multiple times over the same exact fact pattern. Even if someone already lost, you can file again and again and again and again because of the way it's done. And my response is, yeah, sure.
That's
moving
a state
on.
Problem.
What's the next question?
Yeah, that's a state problem. If they want to, change the threshold, that let them do that. That's not the question here. Like, that's not the issue. Like, anyways.
Yeah.
But those, to the extent that they became extraordinary, if anything, might sound in a procedural due process claim, which my friends here aren't bringing. They're bringing a substantive due process claim to SB 8 and its liability itself, and they're attempting to cash that out through some form of enforcement against first Texas officials and then court clerks and so on and so on. I might point out, turning specifically to the assertions my friend on the other side has said regarding court clerks, that it's actually not even clear that injunctive relief against a court clerk would give him what he wants, because under Texas Rule of Civil Procedure 22, a petition is deemed filed upon receipt by the clerk, so the clerk doesn't have the opportunity to reject that petition. It would obviously be a question of Texas law in the event that this court interceded and essentially.
Can I go back for a second from detail to the sort of bigger picture, which stuck in my mind when I read all this roadmap. That should call up a lot of arguments from the briefs. And I thought of Holmes. Two statements.
Oh, here we go.
First, Holmes, remember, had seen John C. Calhoun's theories of nullification, interposition, destroyed really by the Civil War. All right, you read the arguments that said this is sort of like that. Sort. Okay. Holmes said this: I do not think the United States would come to an end if we, the court here, lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the state. All right? Keep that in mind. Now, Holmes was on the court for Ex parte Young. That court said to await proceedings against the company, which is the equivalent of the clinics and the women here, in a state court, and then obtain review in this court, would place the company, i.e. women in clinics, in peril of large risk and its agents in great risk of fine and imprisonment, which you just heard, the equivalent. This risk, the company ought not to be required to take. Now, why doesn't Holmes' statement, in your opinion, illustrate what is the underlying problem here, generally speaking? And why doesn't Ex parte Young point the way towards, not precisely, but point the way towards an answer?
Okay. Can you do me a solid? Can you translate that question into English?
I wish I could. When I saw him going back to Calhoun and Holmes, I was like, where are we going with this right now? I'm not really sure. I got the part about.
Could you rephrase the question, or perfectly someone else rephrase the question?
I got there's an argument in there, like he was going back to like judicial review, and I get that argument like in general.
Do you have a Florida meetup coming up? Do you have a Florida meetup?
Whenever I'm back, which is the time, it will be up in the air, but whenever I am back, I will meet up. I'm trying to see what I can do in terms of going back and forth and making sure.
Well, if you do come back, please make sure to let us know. I might show up.
I will. One. And I will also be for sure in Texas, because I have really
excellent
balance. So I will come to Texas. Where are you in Texas again, Kurt?
Austin.
Oh yeah, I'll come to Austin. Austin's nearby. Yeah, I'll do an Austin.
I mean, I would rather have a question from Sotomayor or Kagan. I actually have some warm spots for Kagan in my heart. Not many, but some. But I've commented that I think she'd actually make a good Chief Justice for some pragmatic reasons, but
Yeah, someone said it in the Jan said it in the chat. The pretentiousness comes off. It drips off of Breyer whenever I listen to him.
Yeah, I don't know if it's said too long in the fair stuff, but he asked these questions, and then earlier he was like, "Oh, I got 6 things from you. Do you have any more?" And text or the whole women's health is like, "Oh, I've got 2 more." I'm like, "Oh joy, great! We just gave Breyer an 8-factor test. Yay!" It's like, could I just Sotomayor? You can ask me a question. It's okay. You're more left leaning. Just ask me a left leaning question. It's fine. I'll give you the right leaning answer if I think that's the right answer. I don't care, but I just want to understand the question that I'm giving the answer to.
That I'm being asked. Yeah.
That'd be great.
2 points, Justice Breyer. The latter being what you're describing would be something of an expansion of Ex parte Young, as I think even my friends on the other side concede. As this court noted that an injunction against the courts themselves through the Ex parte Young device would have been a violation of our whole scheme of government. Well, this court in Grupo Mexicano said, specifically speaking about an expansion from a post-judgment creditor's ability to distrain a debtor's assets, moving to a pre-judgment creditor's ability to do so, that was simply too great of a novel, equitable innovation for this court to be able to permit itself to essentially innovate. To do something that would have been understood in Ex parte Young, in the very same opinion, as the violation of our whole scheme of government is surely a much greater innovation. And if this court is going to stand by its
General
word—
Stone, I think what Justice Breyer is suggesting
thank God.
is that the entire point of this law, its purpose and its effect, is to find the chink in the armor of Ex parte Young. That Ex parte Young set out a basic principle of how our government is supposed to work and how people can seek review of unconstitutional state laws. And the fact that after, these many years, some geniuses came up with a way to evade the commands of that decision, as well as the command that the even broader principle that states are not to nullify federal constitutional rights. And to say, we've never seen this before, so we can't do anything about it. I guess I just don't understand the argument.
See, this question I understand. I understand. I understand the question.
It's clear.
I understand the question. I'm on board.
It's clear. And you can translate, you can read her bias into it. You can read the left one into it.
No, but I get the question.
Clear.
I understand the question.
Thank you. Okay.
It's like, Ex parte Young set up this thing, and some geniuses thought a way to evade it. They went around it. Ex parte Young is insufficient to deal with it. So shouldn't we, because, we have the ability to say what the law is, thanks to Marbury, and which I still think is rightly decided, but whatever, we can move past that for the moment. Because we have this power we have the power to do that. Why shouldn't we say, okay, well, they're geniuses for trying to get around it, but Ex parte Young was Ex parte Young. There wasn't Ex parte Young before that, so why not, modify or deal with something here? It's like, I understand the question. I get it. I'm conceptually on board with the question. Now I can address the question. Thank you for clarifying the question. She has judge-splained Justice Breyer, and I'm happier for it.
It's great.
Let me speak to the latter point you're raising, Justice Kagan, first, and then turning back to the Ex parte Young one. This statute on its own terms specifically incorporates as a matter of state law the undue burden defense as articulated by this court in Casey and subsequent cases. Now, there have been some previous questions regarding whether or not it has incorporated that in every particular regard. There's a separate provision of that law that specifically says that nothing in section basically prohibits individuals from asserting their constitutional rights. And so to the extent that the Texas legislature has either imperfectly or in an incomplete way recorded as a matter of state law this court's recognition of the Casey right, individuals may still erect that right fully and completely. Nothing in this law even pretends that Texas courts could evade that, because it can't.
Well, when it said that,
See, that's
their
a great
rights.
Answer. It's a good answer to it's a good question. It's like, hey, how about this Ex parte Young? They're trying to get around the federal review. They're trying to get around Ex parte Young. What do you say about that? And he says, we're not trying to get around ex parte Young. We're not trying to get around a federal review. There's always review at the end of the line. Once you have a decision from the ex parte Young, only prevents you from getting injunctive relief. It doesn't prevent you from review under other doctrines like Younger, for example, to be able to review a state judicial decision. So once you want, and this is baked in, we've tried to bake in the KC thing. If we fail to do it, you can still raise it up, obviously. So, there's still a process in place. So go through the process and, let it be done. Now, whether or not you buy that argument, if you're Kagan, which obviously you don't, if you're Kagan, but still, it's a good lucid answer to a good lucid question, even if you don't believe the answer. So
yeah, and there are exceptions to the Younger doctrine, right? I mean, correct me if I'm wrong.
Yeah,
there.
probably more exceptions these days than not.
Yeah,
I think the courts, especially some of I think the Supreme Court has basically said don't do Younger. So basically, they haven't said it without actually overruling it. But yeah, Younger says don't do it, except like every case that hears it says ignore Younger. So there's nothing of it left. But yeah, still technically on the book. So yeah.
I took that to be, say, their First Amendment rights. If you had somebody who was counseling someone to get an abortion, say, and then was prosecuted or was sued, not prosecuted, under this law, that they could say, I have a First Amendment right to free speech. And so it would be unconstitutional. I didn't take that particular portion of the law to mean that they could assert third-party rights.
We're speaking about two different portions of the law, Justice Barrett. There is a portion that says something very closely tracking what you said. There's also subsection F, which says that nothing in the section shall in any way prohibit or limit, preclude a defendant from asserting that defendant's personal constitutional rights as a defense, and so on and so on.
Aren't personal constitutional rights not third-party rights? And so the clinic's personal rights would differ from the rights of the woman who's the rights holder?
There's a different provision, Your Honor, that says that individuals may raise the undue burden defense, the undue burden rights to the limit allowed by this court specifically. Now, it may be the case that those three provisions don't perfectly line up, and by interpretative forces, that at some point a third-party right that's recognized by this court can't be perfectly raised as a state law defense. If so, as in all cases, an individual can raise that particular piece or the entire case as a federal constitutional right that, as a default, state court judges who swear an oath to the Constitution just the way that the justices on this court and the lower federal courts do, are presumed that they will apply in good faith, and they are always subject to correction by this court in any appropriate case. What can't occur is what couldn't occur in, for example, New York Times versus Sullivan, or for that matter, Masterpiece Cake Shop. An individual there who thinks that they're going to be subjected to a state court process that's either going to be very difficult for them or otherwise unfair to them in terms of the merits of the decision is not permitted to go to a lower federal court and seek functionally an injunction against the state's trial courts.
General Stone?
Yes,
keep going.
I'm coming to the close of my point.
No, I was just going to refresh my memory because I didn't recall the Masterpiece Cake Shop case.
That was the one dealing with the guy who was selling cakes, but the gay couple came in and wanted a wedding cake, gay wedding cake.
Yes, but ultimately it came down the side that was art, right? And that
they punted. They punted. They said that the original body that reviewed it, the commission that started the whole party, was unduly hostile to religious rights because they said things that were extremely hostile to religious rights, like Christianity's a scam. Not quite, but Christianity's a scam, and they're a bunch of hard. If they supported racism, blah blah blah. So right. So they punted the issue. That was Masterpiece Cake, and that guy's still getting sued to this day. So who knows?
Right. Which it's a very interesting thing. I actually was coaching moot court, and they were doing a problem based off of that case.
It's a great case, though.
Yeah, it is a great case, but I will say, trying to argue in public accommodation laws as applying to small businesses is, to me, a stretch. But then again, we've stretched interstate commerce pretty far.
Oh, well, I was about to disagree with you, and then I'm going to agree with you. Because it's the fact of how small it is irrelevant. Then you say, oh, we're stretching interstate commerce. I'm like, oh, okay, we're going all the way back to challenging Wickard.
Yeah,
would you like to hear about my thoughts about Wickard v. Filburn? I have so many thoughts about Wickard v. Filburn. I'd like to tell you.
Perhaps another time. Perhaps that's a whole separate stream because that gets me worked up as well. Like I was like flipping a table with that. So yeah, that's separate.
Answer your question.
Well, I think all these arguments were the same arguments that Minnesota raised in Ex parte Young itself. I mean, you look at the history of that case, it was an extraordinary controversy in the United States and in Minnesota about the federal court review, and that itself didn't exist before Ex parte Young. In other words, that was an extension of pre-existing doctrine to recognize a problem that the Chief Justice was identifying with deprivation of constitutional rights and chilling on the ability to get judicial review. So Ex parte Young sets out this principle that you can get pre-enforcement review in federal court against state enforcement of laws that are assertedly unconstitutional. And 999 times out of 1,000, or maybe every time until this case, that's a state executive official. It's a pro forma exercise, usually, to identify the state executive official. And Justice Kagan points out there's a loophole that's been exploited here or used here, which is the private suits are enforced by state court clerks or judges. So the question becomes, should we extend the principle of Ex parte Young to, in essence, close that loophole? In other words, put aside the language in Ex parte Young for a second, and that is strong for you, I agree. But the principle of Ex parte Young and the whole sweep of Ex parte Young would suggest extending the principle here, arguably.
2 points, Your Honor. One, no, precisely because this court has disclaimed the power to create such an innovation in Grupo Mexicano. To the extent that were still an open question, my friend's arguments on the other side might militate towards having one exception there. But this court has already disclaimed the ability to give itself the power to essentially create a novel, non-traditional cause of action. And if the language that we're discussing in Ex parte Young means anything, it means that certainly an injunction running against a state court to prevent the adjudication of a state law case is something.
Do you know this case, Grupo Mexicano?
I was literally Googling it right now.
Yeah, because you can educate me on one. Since I already gave you one, I'll give you one. What's Grupo Mexicano? Explain it to me.
Okay, in Grupo Mexicano, apparently a bond fund purchased $75 million in unsecured notes from Grupo Mexicano. It involved a road construction program sponsored by the government of Mexico. There were some financial troubles, the missed payment on the notes. The alliance accelerated the payments and filed suit for the amount in federal courts. And then the alliance filed a preliminary injunction restraining the holding group from transferring its assets, saying that it was in risk of insolvency. And then the alliance sought monetary damages and no lien or equitable interest was claimed. The district court issued a preliminary injunction and ordered GMD to pay a $50,000 bond. The question was, does the district court in an action for monetary damages have the authority to issue a preliminary injunction preventing the defendant from transferring assets in which no lien or equitable interest is claimed? Okay, that's interesting.
I would think no. I mean,
I would think no.
Why
as well.
would you?
If you have no lien and you have no equitable interest, then what color of law or equity do you have? You have no color of law or equity. Right. So you should not be able to injunctively stop that.
So this would be the equivalent of, I have a lien against your house and you want to sell your car and I want to prevent you from selling your car. That doesn't make any sense.
No, not well, exactly. It's like something that's for which you have no lien on.
Yeah, exactly. Right? Yeah.
Like it's a potential lien, but not a lien. It's like, well, that's
I have a lien against your house, but not your car. You want to sell your car, but I want to prevent you from selling your car.
Which was shockingly a 5-4 decision. Scalia was the opinion guy on this one. They said, no, they do not have the authority to do that. Scalia said the district court lacked the authority to issue a preliminary injunction preventing defendants being sued by creditors from disposing of their assets pending adjudication of the creditor's contract for monetary damages, because such a remedy was historically unavailable from a court of equity, allowing federal courts to grant creditors such injunctions, as Scalia said, in quotes, could radically alter the balance between debtors' and creditors' rights and might induce creditors to engage in a race to the courthouse, which might prove financially fatal to the struggling debtor. Yes, yes, yes. You don't want them to do that. Creditors are already horrible enough. We do not need to give them more power in America.
Yeah. No, that makes logical sense.
Yeah.
So 5-4 does strike me as odd. Maybe it's deeper once you get into it, but on the surface level, that sounds right.
Well, okay, if you want me to go down the liberal side here, dissenting because their banker friends weren't happy with that. I mean, I don't know, because it was Stevens, Souter, Ginsburg, Breyer were the dissents. and majority was Rehnquist, O'Connor, Scalia, Kennedy, Thomas.
Okay.
So this is a Rehnquist case, a little bit of a throwback.
Yeah, a little bit, man. He was good. I got to see him a couple times at the Supreme Court.
Yeah.
So, you know, his last days, though, man. If you ever listened to the oral arguments just before he passed away, man,
rough.
Yeah, he sounded like death, man. It was not good.
I didn't listen to those, but that's what I had heard. You know, but you've got to, you know, I admire somebody who's sticking around till death. I mean, it's sort of like I believe this is I'm in it till I'm out. You know, and if your mind is sharp enough, then by all means, right?
I mean, yeah, I think that's true. I mean, even or not even. I'm not sure why I put it that way. But Ruth Bader Ginsburg was known for her fast writing, even up to the end. Her ability at oral argument, maybe not as sharp as she was, but her writing ability and her ability to write was still as sharp as it ever was. She forgot more than I ever knew, so it's pretty critical.
That's why I'm sitting here sometimes with this, and I look confused or lost. I'm like trying to understand the arguments. Like it's sort of that meme of like the algebra and calculus going together, and I'm trying to figure out what point they're making because this is such a higher level of abstraction. I, in my day-to-day, deal with very practical things, very practical applications. So for me to have to like kick my brain into this higher abstraction mode is very odd. It's a nice thought exercise. It's a nice thought exercise because you never do it, right? That's why you love it, because you don't do it in the day-to-day normally in the practice of law. So it's very fascinating.
Yeah. I always love that feeling of like the abstractions and pushing up into the higher levels of abstraction. There's something very intellectually rewarding about trying to feeling like I have to tune my intelligence up or kick my intelligence up to try to play at that level. And usually I can do pretty well, but definitely sometimes in the Supreme Court, because I don't know all the things, and sometimes I'll get it really like, I don't know what the fuck is going on. It's like, well, maybe if I listen to more cases, maybe I'll understand it all eventually.
Procedure is the one thing that it was not I did not book Civ Pro. Let me put it that way. That is not the one I booked, you know? So this is the one that I'm like, con law, great. Oh, con law was fine. But the Civ Pro and like getting into the exact procedures sometimes where I'm like,
I couldn't find the Erie question on my exam. I couldn't find it. 2 hours into the exam, I went up to my teacher. I'm like, I know you can't answer this question, but I'm going to ask it anyway. Is there an Erie question on this exam? She's like, I can't answer you. I'm like, okay, thanks. I just go
there always is an Erie question on the exam. Like,
she did a pretty good job of hiding it. I think half the class missed it. So she did a good job of hiding it, though. But yeah,
good.
And she didn't help. It didn't help that during the review of what she was doing, like the review, but at the end, you know, before the exam, she's like, yeah, once I didn't give the Erie question, so she's like, prime my mind that that's a possibility. So I'm like, that was mean.
Yeah.
Entirely foreign to traditional.
Do you agree that there's state action when the state court clerk dockets the case?
State action in the sense of the 14th Amendment, perhaps?
Yes.
I suppose that a state court clerk taking on a clerk is acting as part of the state in that case. Yes, Your Honor. But the key part here is that my friends on the other side aren't even alleging that the docketing of a petition ordinarily is a violation of the 14th Amendment or is a violation itself. It's the nature that potentially later down the line, that SB 8 case might in fact be adjudicated negatively against them. A state court clerk who receives petitions and puts them on the docket, and a state court judge who is required to apply this course precedents and everything else, they're not Article 3 adversaries when they're doing that process. They're not committing a wrong.
I think the theory is that the enforcement of the law is adverse to the plaintiff's interests and causes injury. And this state official, let's say the clerk, is part of within the chain of state officials who have some connection, which is the language from Ex parte Young, some connection to enforcement of the law.
But respectfully, Your Honor, that some connection to enforcement was referring to all the way up the connection was the Attorney General bringing the suit. To stop the commencement of a suit in the language of Ex parte Young meant an anti-suit injunction against an official to stop them from bringing litigation.
Can we go to that question of the Attorney General, which hasn't been raised before? The Attorney General has been sued here. I know that the argument is that it doesn't enforce these laws. The Attorney General here doesn't enforce these laws. But the district court suggested that wasn't true. It has some direct enforcement authority with regard to SBA's fee-shifting provision concerning any legal challenge to any abortion restriction or regulation, and may also have some constitutional authority under Texas law to enforce Texas law. The Ex parte Young fiction was that if there is an agent who can enforce the law in part or in whole, and they're sued, then everyone else in the enforcement chain is enjoined. So if every private citizen here has been deputized by the state to enforce this law for the bounty, then why wouldn't an injunction against the AG bar those citizens from going into court? Just the way it would bar district attorneys or police officers from arresting people once that order has been issued, or district attorneys from prosecuting those people for a violation of the law that a court has found unconstitutional, until the Attorney General, the representative of the state, is not legal.
It's not a bad question. I don't think it's really necessary because I think it's treating these what I think Thomas's point is still right, that these are private attorney generals. They're not really under the authority of the attorney general. So strictly speaking, enjoining the attorney general because they don't work for him is a little off. But if you want to just do it as a legal fiction, it doesn't really matter to my mind. Like, does it really matter if you're saying, okay, we're just enjoining all the private people because they're basically state actors, or we're enjoining the attorney general and creating the legal fiction that they're all working for him anyway? It's like, does it really matter that much? Not to my mind.
I don't like the characterization as deputized, because it's not really that. They're just being empowered, right, to bring a civil suit. Am I missing something here? Like, what authority of the state, what color of the state are they being given? I'm not sure.
Well, they're being given the power to bring the civil suit as private attorney generals, which the attorney general has the power to bring civil suits.
But that's just like, it's like you're giving one specific power just because, okay, it's like
it's a very limited kind of.
Let me put it this way. Just because, FedEx and UPS deliver boxes doesn't mean they're members of the U.S. Postal Service with all the rights, protections, and benefits of the Postal Service, right? You're giving them one task that's similar. That doesn't mean that just because they can do this one thing that the other person can do too, doesn't mean they assume that they're standing in their shoes, right? I'm not totally comfortable with that argument.
Yeah, I wonder if there's a distinction to be made there about like aspects of state power that are more classically considered state power versus that are not. So like maybe the delivery thing is not thought to be a classically state power because obviously in the Constitution they have the ability to regulate postal roads and stuff like that. So it is a state power, but unlike other state powers that are thought to be more exclusively state power. Mm-hmm. So maybe this is in a different category than the FedEx example. So maybe there's a distinguishment to be made there somewhere.
Yeah, I get what you're saying. It wasn't a perfect hypo. I was just trying to quickly come up with some sort of hypo here because this. Did
I do it bad by attacking the hypo? I'm sorry.
No, it's fine. It's like it's hard to find something that's in this middle ground, right? Because bringing a suit, to me, I'm okay with generally, as a general principle, more people. This sounds bad, and as a lawyer, whatever. I'm okay with greater access to the courts than less access to the courts. So, sure. And I'm aware of the floodgates arguments, right? And you can always put protections against the floodgates arguments, but I don't have a huge issue with just opening up that power, that limited power, right? And then putting some limit on it as a private right of action.
Okay, I'll think about it some more.
Yeah, let me think about it as well.
2 points, Your Honor. We'll say one on the Attorney General's side and then one on the private litigant side. On the private litigant side, there is no deputization of individuals. The Attorney General...
Assume I disagree because you didn't answer to my satisfaction Justice Thomas's point that I've never seen a tort that doesn't give you redress for your harm. It gives you redress for bringing the suit, the bounty. And whether you need to prove injury for standing is irrelevant to what qualifies you for the bounty, which is injury doesn't qualify you for that. Just bringing the suit does.
Speaking only specifically in this case, because I don't want to push back. I understand the direction of your question, Your Honor. The Attorney General, just like every other Texas official, lacks the power to either direct a suit, to order that a suit be dismissed, to intervene in a suit, to otherwise.
You don't understand the point. It is part of the enforcement mechanism of the suit. Not the whole, because the state has chosen to deputize an entire swath of citizenry to do that for it. But it retains some direct and indirect enforcement power. So answer the ex parte Young fiction. We issue an injunction in the traditional course against an AG, and we expect everybody to understand that they're precluded, who acts on behalf of the state, to be precluded from continuing under an unconstitutional law.
The most direct answer to your question is that an injunction running against the Attorney General wouldn't change anything he could do. It wouldn't change any ability to bring a suit. It wouldn't change any ability to stop a suit. He couldn't withdraw.
General Stone, I mean, think about the question in this way. Suppose there were not this private enforcement provision. Suppose this were a normal law, a heartbeat law. You would sue the Attorney General, wouldn't you?
If the Attorney General were the one charged to sue, I would assume so.
And well, if the Attorney General were the one charged to sue, I mean, the actions would not be brought by the Attorney General. The actions would be brought by local DAs, wouldn't they?
Well, Your Honor, the difference is local DAs in Texas are locally elected officials that are not accountable to the Attorney General. So I'm not trying to push back against the hypo, just the facts you've given me fundamentally change whether or not they'd be accountable to the AG in some sort of state law.
Are you saying that in a normal heartbeat abortion restriction, a suit against the Attorney General would not be sufficient because local district attorneys are bringing the suits?
It would depend on whether or not it was charged by the Attorney General's office to sue or by county DAs who are not elected or essentially not accountable to the Attorney General anyway. But if I may modify your hypo a little bit and say that
I guess what I was suggesting was that in just the same way that the Attorney General does not have direct line authority over the DAs, but nobody would dream of bringing a challenge to ex parte Young in that circumstance, so too the fact that they don't have direct authority over these private individuals exercising delegated power shouldn't matter for the same reason.
In the example you're describing with county and district attorneys, individuals would be able to bring ex parte Young challenges against those individuals, to be sure, but not against the Attorney General. And the key difference here would be those individuals, the county attorneys and district attorneys, would ultimately be able to enforce the law by bringing a lawsuit. The reason that we're sort of the hypos that I'm pushing back against here are that the Attorney General simply doesn't have any control of the procession of SB 8 lawsuits in any way. He doesn't have a mechanism such as in the key TAM context to take over the litigation. He can't certify that a lawsuit is not in the state's interest or something like that order and order it dismissed. He has none of those sorts of mechanisms whatsoever. Because of that can't possibly, at a minimum, redress the injuries of the petitioners unless this court were to say that private individuals who have not yet articulated they plan to bring suits or anything like that are somehow agents who are acting in concert with the Attorney General. The problem with that is that, again, we have no authority over them. The basic concept of agency is that there's a principal and an agent, and the agent is responsible to the principal. The principal in this hypothetical, the Attorney General, exercises no supervisory authority whatsoever over putative suit bringers. And we're not acting in concert for the ordinary factual reason that, in fact, we're not being approached. This is just a matter that can also be resolved in the district court if it gets that far. We're not being approached by directing anyone else's litigation. It's individual people are choosing to bring or not bring these in pre-enforcement challenges in state court, I mean.
Can I ask you about the implications of your position for other constitutional rights? The amicus brief of the Firearms Policy Coalition says, quote, this will easily become the model for suppression of other constitutional rights, with Second Amendment rights being the most likely targets, end quote. And it could be free speech rights. It could be free exercise of religion rights. It could be Second Amendment rights.
Can you stop it here?
If this position is accepted.
I mean,
this is what we were all saying. We were all saying that. I mean, you said it very fervently, Kurt. I mean, but all of us were like, guys, I don't care how you feel about abortion. I don't care how you feel about whether or not, every attack against abortion is good. This is a bad precedent because other states are 100% going to do this. They're already trying to attack the Second Amendment in so many other ways, guys. There's so many other ways they're attacking it. You think they're not just going to add this to the Rolodex? It's bad precedent for attacking the Second Amendment and other rights.
And Nick was trying to push back on me, so I can so I could a little bit. Yeah, he seemed to. I don't want to unduly, challenge the man when he's.
I just want to understand his take because I didn't hear it. Yeah.
So I don't want to. I won't berate the man because he's not here. But what I think will be the fairest thing I can say is he seemed to think it would be harder than I did to export the logic of SB8 into other contexts. He thought it would be. He didn't think it would be as easy or necessarily doable in all the contexts. Where I was like, it might take a little bit of work, but I think you can get there. Was basically my conclusion. So
I definitely think you could create an SB8 type thing for firearms, and it doesn't even have to be direct. It could be indirect, right? You could just go after people whose actions with firearms caused you to be outraged, right? I mean, the tort of outrage. That's.
Yeah, that's right.
Think about the application of that in a firearms context, and
I just for the record, always, of course, I'll state this as I stated maybe times before. One of the things I really love from the whole law panel is that we do have differences of opinion. It makes me think.
That's good.
I know, I love it. It's great. It's great because I've changed my mind before. I've changed other people's minds. It's and there's been issues where I have thought about it and I haven't changed my mind. On this whole thing with Andrew Branca. On this whole issue with the self-defense and the Chad shooting, Andrew wants to go to the exact moment of the shot and whether there was self-defense at that exact moment. I'm like, I'm not slicing it that thin, and he seems like he's slicing that thin, and so I'm like, geez, he is the expert. So let me go mull on it for a while. I went mulling on it for a while, and I'm like, no, I still disagree with you.
I'm with you on that. I don't like the method of examination, and I'm not sure why we're going down that road. I'm with you on that one. And then we got into that when I was on Eric Hunley's show last night. I mean, Joe Neerman, he got up and he was talking about the milliseconds and 0.5, and I'm not once again. I love that we have these disagreements.
The entire point is to some degree praise him for being able to challenge me and make me think because I want to be able to think. I might be wrong,
right?
And then I'll be corrected. I'll be less dumb.
But I may correct them, and they may not be thinking about this. When you call yourself Pro 2A and you're not thinking about the more robust. The robust outcomes, including the fact that, hey, you're narrowing this window where you're able to use your weapons. So what does the Second Amendment even matter if you can't use the gun that you have? Okay, you're allowed to own it. Awesome. But I can never fire it unless it's within the perfect 0.1 second interval because I know you're freeze framing this. It's that's preposterous.
Then I, genius to the cause, recently did it was part of a larger stream that I did a cutout of where I basically went through my interpretation of the Second Amendment and basically tried to, I think it took me about 20 minutes to basically go through the general outline. And just people in chat were like, wrong, you're wrong. This is what you want to be. You should go talk to, who was it? So-and-so because they know the history better, to go talk to Nick, wait till I rat you out to Nick, wait till I tell you about, to these various people. And I'm like, I might be wrong. I've done my due diligence. This is my analysis. One of the things that really sort of I try not to react to the chat as much, but they is like, well, this is only what you think because you want it to be true. And I'm like, it's just like I've done this complicated analysis. I could be wrong, but I'm just waiting for the rest of LawTube to look at my 20 minutes and start a whole war on Second Amendment interpretation. Like you're wrong. Because I think Andrew Branca says he's absolute Second Amendment, although you can't use it. So I'm waiting for him to say how my interpretation is wrong because I don't understand the history or the scope of the weapons and blah, blah, blah.
And we all will agree on different things. We'll say, here's our interpretation. Here's the way I would take this, right? Because I agree with Andrew. I agree with Andrew on a lot. I agree with him on automatic weapons, for example. We're on the same page. We're both like, hey, automatic weapons. Cool. But, where we disagree regarding this window of self-defense. And I know he's the expert and I respect that, but I think he's wrong. So
I knew it was in jest. If I didn't say that, I'm sorry that I didn't say. I knew it was in jest, but it's just but I was putting myself out there. It's because I have, I read all these briefs. I read all the briefs in Heller and McDonald. I did so much analysis in law school in it, and this is what I think they were talking about, and here's my rationales for trying to interpret that way, and blah blah blah, and just people in chat is Yeah, we don't have to talk
Yeah,
about it too much.
sometimes you got to ignore the chat. I mean, the chat, I remember one time during the Rittenhouse case, I was describing generally something regarding firearms. And I did a generalism without giving some specific detail. Because once again, I'm not familiar with the exact gun he's working with, the exact model he was working with. And they're like, Legal Mindset knows nothing about guns. I'm like, yes, that's right.
I always love that when I change frames of reference and someone misses me changing frames, because that happens sometimes. I'm like, so I'm like, oh, maybe from Goskowitz' point of view, I mean, at least we could have an arguable, intelligible discussion about it. It's like, oh, so you're saying Kyle Rittenhouse is in the wrong? I'm like, I'm not saying anything like any of those things. I'm trying to one issue at a time, guys. Yeah. The joys of the law tubes, and you feel like sometimes people don't quite understand your point, but yeah.
And even the other lawyers, right? Sometimes we'll miss each other's points. I'll get part of your argument, but I won't get your whole argument because you're thinking about something from a different state of mind than I am. So that's why it's good to discuss these things and get it out. Especially I like formats like this, Kurt, where it's like me, you, maybe one or two other people, because then we can really get robust discussions. Sometimes when the panel gets massive, then it's just like squawk, squawk. It's.
And then I always hate it when I feel like I've got like a good point or a good joke. And I have that feeling of watching the joke just slip away as people keep interrupting. Like 4 people down. I'm like, I can't make this joke anymore. That moment's passed. Damn it.
Yeah. All right. Let's get back into
the theory of the amicus brief is that it can be easily replicated in other states that disfavor other constitutional rights. Your response?
Your Honor, in several of those circumstances, individuals were concerned that a lack of immediate pre-enforcement federal court access would cause them ruinous liability or otherwise suppress their ability to exercise those rights, have turned to Congress and succeeded. The Protection of Lawful Commerce and Arms Act, for example, was specifically passed in response to state tort lawsuits in which there was no immediate federal review that could only at most be brought here.
Well, for some of those examples, I think it would be quite difficult to get legislation through Congress. Are you saying absent that, that Second Amendment rights, free exercise of religion rights, free speech rights could be targeted by other states in this using the Ex parte Young language on 163 and to really infringe those and to put huge penalties to the Chief Justice's hypothetical, say everyone who sells an AR-15 is liable for $1 million to any citizen. Uncertain what the Second Amendment status of that ultimately will be, which is where those laws will have purchase. Would that kind of law be exempt from pre-enforcement review in federal court?
My answer is on whether or not federal court review is available does not turn on the nature of the right. So we can put in religious liberty.
So we can assume that this will be across the board equally applicable, as the Firearms Policy Coalition says, to all constitutional rights.
Yes, but I'd add one more point, Your Honor.
And you've also said the amount of the penalty doesn't matter. $1 million per sale. A state passes a law, anyone who declines to provide a good or service for use in a same-sex marriage, $1 million is sued by anyone in the state. That's exempt from pre-enforcement review.
It can't possibly depend on the dollar amount if it's an infringement on the right? Whether it's $1 or $1 million, it can't be like, oh, it's $1, so it's okay. But $1 million is like, whoa, way too much. It's like
it still infringes.
No, it's still. If it's going to infringe for $1 million, it's not going to stop infringing for $1.
Again, Your Honor, what we'd have to have, for example, in
is that a yes or
yes? I'm sorry, Your Honor. Yes,
that's a yes. That's exempt from pre-enforcement review
in the sense of that federal courts' doctrines and Congress's statutes defining the jurisdiction of the federal courts would have to be modified by Congress.
And General Stone, your answer to Justice Kavanaugh, which is go ask Congress. I mean, isn't the point of a right that you don't have to ask Congress? Isn't the point of a right that it doesn't really matter what Congress thinks or what the majority of the American people think as to that right?
Kagan.
Respectfully, Your Honor.
Any day you want to apply that to the Second Amendment, baby, I'm just 100% on board, right? It's like, any day you want to say, man, this is just a right and it's a right, full stop.
Yep.
I'm there.
It's great. We don't have to ask. We don't have to force it.
The answer to that in both part of Justice Kavanaugh's question is that just as in the other circumstance, just as I'm asking for here for Texas state court judges, we have to assume that other state courts judges are in fact going to faithfully apply the Constitution, its rights, and this court's decisions. It will have to occur through the state court process to be sure, but that is an adequate substitute, an adequate venue.
Within the state court process, maybe many years from now, and with a chilling effect that basically deprives people who want to exercise the right from the opportunity to do so in the maybe long-term interim.
Please.
Thank you. No doubt that's the case in many kinds of lawsuits, including constitutional ones, Your Honor, but no one's thought that litigation delays had constitutional dimension for purposes of expanding access to the federal courts before. I don't think this case should be the first one to start.
Now, this is an interesting aspect just in terms of like the procedural aspect of the Supreme Court, so forgive me for just a second. The reason Chief Justice Roberts just said please has to be because the red light is on, right? He sees the red light is on and he's kind of looking to the Chief Justice with those eyes of like, should I continue, right? And so he says, please continue. So his time has expired, but this seems to be something new that they're doing, at least since Zoom, and they're back in the room, even though there's no one else in the room other than
the Supreme Court is back in the room.
Yes, the judges are, and the attorneys are. It's not open to the general public, but
do we know their vaccination status, Kurt?
We do not. We do not know that. But what's interesting now is that even when their time is expired, the Chief Justice seems to be doing this thing where he still goes one by one and asks the justices all individually if they have questions, which incidentally, I kind of like in terms of procedures to make sure like no one got left behind. It's just an interesting procedural change. So,
and no, it's good. But I mean, honestly, there are some procedural updates that are handy after a while, after X amount of years. And sometimes with something as, solidified as the Supreme Court, you are reticent to change any procedure, but then you get something that's new and actually pretty good.
It was only 2 or 3 years ago that they made the change where the first 2 minutes of the oral argument are interruption free. And I liked that change. When the first time they did it, I was like, what the fuck is this? Because it's like, you're so used to getting interrupted. But now, now by rule, it's like you get 2 minutes for free. So you get to lay out your 2 minute perfect opening and lay it out in 2 minutes of perfection. And you better believe how much time do you think these Supreme Court advocates are working on those first 2 minutes? How much time does it take to write those 2 minutes? All the time. So much time because you want it to be perfect because it's like uninterrupted. But the fact that they allow them to do it is a great change.
Yeah, I agree.
Okay.
Thank you, General Stone. I have just one additional question. There was a statement in one of the briefs filed below, not by you, that said, quote, states have every prerogative to adopt interpretations of the Constitution that differ from the Supreme Court's. Does the state of Texas have a position on that?
The state of Texas' position, Your Honor, is that the courts of the state of Texas will absolutely faithfully apply any decisions of this court as they understand them to apply to federal cases of federal law faithfully, and that the other officers within Texas are bound likewise to take the interpretations from this court and federal law and to faithfully implement them.
Thank you, counsel. Justice Thomas? Justice Breyer?
Just a quick technical question. In reading Ex parte Young, I got the impression that the enforcement mechanism was really private shippers or passengers who were supposed to sue the railroad. The Attorney General didn't have any direct power. He just had a kind of residual power. So I looked up the Texas statute. Seems like the Attorney General here has the same kind of residual power. Hard to see that in Ex parte Young because it was a contempt case, but it seems to be there. And they say this Attorney General with just the residual power, we can go sue him. Then all your problems would, in that case, but they didn't appear. And it turned out that the statute nobody enforced because it had been said to be unconstitutional in the AG's case. So is there a difference I overlooked?
So pause here.
No,
I actually forgot the facts of Ex parte Young. I just know the holding, what the outcome is.
I don't know what the Ex parte Young is about. Who knows what it's about? Something about a railroad, apparently.
There's so many railroad issues, guys. Like railroads cause
true.
90% of our decisions.
A lot of them on the federal level, are about railroads or sometimes ships on the waterways,
Yep.
or allocation of water with
Right.
a lot of state versus state stuff. So yeah.
Yep. Diversity.
Well, in that case, it's
Oh, sorry. No.
original
Sorry. State
jurisdiction
versus state, not
because
diversity.
states suing each other. Yeah.
Yeah. Still waking up.
Diversity, man.
I was thinking Erie.
Yeah.
Even given all of those provisions, Your Honor, even given all of those facts, nonetheless, this court in Ex parte Young described an injunction running in state courts and state clerks as a violation of our whole scheme. In this particular case, the Attorney General has no connection whatsoever, not even an attenuated one to the enforcement of that law of SB 8.
Justice Alito?
What can you tell us about the state multi-district litigation? This law was enacted, I believe, in the middle of May. When were those suits filed? Where do they stand now? Are they being delayed as a result of the federal court litigation? How quickly might
What are we talking about now?
expect to see
So
a
this
decision
is
in that case?
Pause it here. This is a very practical question. I actually really like this question because it's sort of like he's asking, like, okay, what's the reality of the issue here? Like, what is going on with the litigation that's in the state, that's within the state related to SB 8? So what's the status? So what he's saying is that what's the practical effect here, which I think is a damn good question.
No, that's perfectly fine. I just lost the plot because when he said state multi-district litigation, the first thing I went to in my mind was interstate district litigation when there's multiple different states and we're like consolidating into one circuit. I'm like, what the hell are we talking about with multiple different states and multiple different circuits and consolidating through the multi-district panel? But no, they're talking about within the state. I just kind of lost the plot because when I heard state multi-district, I went to the completely wrong place in my mind.
It's the multiverse, Kurt.
Yeah.
I can answer some of those questions, Your Honor. They were filed fairly promptly, I believe just before SB1's or SB 8's effective date. There are currently 14 of them proceeding in a multi-district litigation. There's motions for summary judgment are due 10 days from now. So I assume that the judge is acting on a highly expedited schedule. As to whether there'll be post-motions practice or other than that, I couldn't say for you, but I have very little doubt the Texas courts are going to treat this as a case to treat very expeditiously.
They were filed around the time when SB 8 took effect or around the time when it was enacted back in May?
I believe it was around when SB took effect.
And are they being delayed as a result of the federal court litigation?
It appears that again, since a motion for summary judgment deadline has been set for 10 days from now, that they're continuing apace, even given this court's grant of certiorari.
My understanding is that they involve only state law claims and that the plaintiffs in those cases have not raised federal constitutional claims. Is that correct?
That's incorrect, Your Honor. At least one of the litigants is Planned Parenthood, where they have raised explicitly the federal constitutional undue burden defense. So I know at least in that one, I couldn't swear to each of the others, but I know in that one, they're certainly explicitly raising this court's articulation of the case you write.
All right, thank you.
Justice Sotomayor?
Counsel, Grupo Mexicana talked about equitable remedies involving private parties.
Could be worse, could be Breyer.
In 1789, we had just created a new system of government. So we never had an ex parte Young or any other injunctive relief between governments because we didn't have anything like this before in England or anywhere else. The system of government we have created. Now, I take and I listen to what Ex parte Young said about not interfering with the work of the coordinate branches, ongoing work of the coordinate branches. But one thing that we said in Cooper versus Aaron was equally important, and that is constitutional rights declared by this court can neither be nullified openly and directly by state legislatures or state executive or judicial officers, and these are the key words, nor indirectly through evasive schemes. So given what I just said, that principle is inherent in the Constitution, why am I limited by Grupo Mexicana? Why would I be looking to a history that can't exist by its very nature? What does exist are the words we said in Ex parte Young, which was, we are charged by Congress in ensuring that federal rights are respected directly or indirectly. So could you respond and tell me why we're limited by anything in terms of what an equitable remedy would be like, assuming we were to find, and you can challenge the assumption, but you'll waste your time, assuming we were to find that this scheme was intended to chill abortions that were constitutional.
Taking all of the assumptions as I'm obligated to, Your Honor, at a minimum, this court's statement in Grupo Mexicano saying that Congress was the one that vested the federal courts with equitable jurisdiction in the first place suggests that whatever equitable jurisdiction occurs in the courts occurs because Congress gave it to them. The court recognized a limitation in Grupo Mexicano that I don't understand that it was across a public-private distinction, but was a separation of powers distinction between whether or not this court or Congress had to expand beyond traditional equitable remedies available. And if nothing else from Ex parte Young is significant on this point, the one thing that the violates our scheme of government point is relevant for is that plainly is an indication that that kind of injunction is not traditional equity.
Justice Kagan? Justice Gorsuch?
Just a couple questions. With respect to the MDL that Justice Alito was asking about, is there anything in that proceeding that prohibit parties from bringing a pre-enforcement action against Texas's law for violating the Constitution?
No, Your Honor. In fact, again, there are individuals who are raising pre-enforcement SB8 challenges right now against
is a pre-enforcement action in state court on this issue now?
Right now, yes.
And there's nothing to prohibit them from bringing one?
Nothing to prohibit them whatsoever other than identifying a private plaintiff who's made a reasonable threat of suing.
Okay. And then on the chilling effect question, it's been suggested that the chilling effect here is different in kind because of bounties and the involvement of private persons. And I'd like you to address that. Often constitutional rights, of course, can only be enforced in a defensive posture when an individual is faced either with potential liability, punitive damages, but also, of course, civil fines and even criminal sanction, including prison time. And I guess I want to understand your argument as to why this is or is not different in kind.
Well, Your Honor, it's certainly not different in kind. In fact, it's much milder in degree than a variety of the constitutional rights we've been discussing in the state court, potential downside risks from failing in state court litigation. Again, in New York Times v. Sullivan, there was quite a great deal of exposure potentially from that defamation action, individuals suffering potentially criminal sanctions for Second Amendment rights all the time. $10,000 liquidated damages provision and potentially a fee shifting mechanism on top of it is comparatively mild compared to, again, incarceration for asserting a Second Amendment right. I mean, realistically, none of the complaints about the plaintiff favoring procedural rules in SB8 would amount to anything even considering a procedural due process violation if this law were about making widgets. They're only sort of sideways way of casting procedural due process aspersions on an attempt to get fundamentally a substantive due process pre-enforcement challenge.
Can you stop there?
Yeah, sure, of course.
My brain is hurting. Kurt, can you help me understand some of that? Because that really, what is point there? It was just really hard to follow about Sullivan, about New York Times versus Sullivan.
All right, so let's see. The chilling effect here is different kinds of the bounties.
Mm-hmm.
Constitutional rights can only be enforced in constitutional and defensive posture, faced with liability or fines. And I guess I want to understand why this is different. Okay. It's certainly not different kind. It's much milder in degree than other ones. In New York Times versus Sullivan, which of course deals with freedom of speech and freedom of press, quite of exposure potentially from defamation for Mr. Sullivan, the state official. Individuals suffering potential criminal sanctions for Second Amendment rights all the time. So I think he's moved on to a different example, but yeah. So he's like,
he moved on to Second Amendment.
He just moved from one to one to the other. So $10,000 is comparatively mild compared to what was facing, which, isn't real. And the fee shifting statute, which is not really a great argument, again, because if it's an infringement, then it shouldn't really matter. I guess you could say there's a difference in kind between the criminal sanctions and civil sanctions.
But it's still an infringement. I don't really
Yeah.
buy that. Like whether or not you're telling me you're going to hit me with with like you said a $1 civil fine, or you're going to throw me in jail, you're still infringing on my rights. I mean, it doesn't matter one way or another to me. I think it's an infringement if it's an infringement, period. Right? It's just okay. You're gonna be more sympathetic if you're being thrown in jail for asserting your Second Amendment rights. You're going to be a more sympathetic case, but it's still an infringement, even if it's a small fine.
Yeah. So I think.
Although we do treat civil penalties, i.e., fines, differently than we do deprivations of liberty.
But New York Times versus Sullivan is defamation. That's purely civil.
Yeah.
So it doesn't quite work for the analogy.
Yeah. There was no potential for jail time in New York Times versus Sullivan, right? So,
and then this is. None of the complaints about plaintiffs' favored procedural results would amount to anything, even considering a procedural due process violation if the law were about making widgets. I suppose that's true, but
that's the part that I was really struggling.
Well,
like,
but
okay.
but the analogy's off because there's no constitutional right to make widgets. So the analogy doesn't really work. So yeah, if you put in place all these regulations dealing with widgets, which
it depends what your widget is,
the widgets and the danger of the widgets.
Yeah,
you might very well do.
Is your widget cocaine? Like, yes, then definitely there's,
or is the widget an industrial factory that's really dangerous and like whatever, right? Is the widget a paper plant? Depending on the nature of the widget, yeah. So it doesn't quite work because there's a constitutional right at issue. So yeah, it leaves something to be desired. The argument's not great.
I want to follow up on Justice Gorsuch's question about the pre-enforcement challenges in state court. And you said it's just a matter of finding a private plaintiff to sue. Is that right?
A private individual who holds them out that they're going to sue because.
Right. So in the state court, then, if I understand that answer you gave to Justice Gorsuch, the same problems that pervade this pre-enforcement challenge exist there. That even if they identify a private potential plaintiff who expresses the intent to sue, the injunction would run only against that one plaintiff, and we would have all these same problems because the attorney general can't be sued in state court. So it doesn't resolve. It's not ex parte Young style, I guess is what I'm asking.
No more than that. Probably there's no such ex parte Young remedy against individuals generally. Now, if multiple people acted in concert, they could all be joined. I will say there is one feature of this law that has been brought up before, which is that if an individual who has an action brought against them pays the statutory damages amount, then no further liability can be brought by anyone for that same act. And so that would extinguish the down the line possibility of sort of an infinite series of lawsuits. So that has
for that one abortion. But I guess what I'm getting at, and I think the answer, because you're shifting, is that you cannot get kind of global relief in the same way the pre-enforcement challenge under ex parte Young in federal court gives you relief from the prospect that the statute will be enforced against you. And you're saying that in state court, these pre-enforcement actions do not offer that. They're just on an individual by individual basis.
Yes, Justice Barrett, the same way that an injunction against all individuals known or unknown in the federal court would be a remedy unknown to that court either.
You've answered my question. Thanks.
Counsel, rebuttal.
It sounds like Justice Barrett has some issues there,
Yeah.
He answered my question. Yeah. I mean, no one here is a fool. And they're not going to take this bait, right? With this problem, It's like the only thing that really is strange about the whole thing, and I guess we'll get to this when we get to the actual decision, is I was a little surprised that a decision is being made right now, as opposed to being given along with the Mississippi case, because one would imagine one way or another, the Mississippi case is going to somewhat speak to this. Potentially a lot. So
Mississippi will speak to the substance of the attack. I mean, I think this deals with more of the procedure of who can
there's
file
that.
what.
I suppose that's true. It's just like it's a little bit. It might be mooted by the substantive change.
The SB 8.
Yeah, well, some of the attacks might maybe. Yeah.
But I think that the procedural clarifications, because this is not a unique snowflake, are to a certain extent important because they're going to open up a separate collateral avenue of attack.
Yeah. All right, so we got 4 minutes left in rebuttal, and then we'll at least read the syllabus and see how we go from there.
Yeah, I've got a hard stop in 30 minutes here. So.
Oh dear. Well, that's very sad for me.
Rebuttal, Mr. Herron.
Are you going on Nick's channel?
No. I've got an appointment here.
I'd like to begin by picking up on the point that, or the question that Justice Barrett was just asking. Those FIT 14 pending state court proceedings, any relief would be against only those defendants who were sued in those proceedings, the private defendants, they're not the state. And in fact, the defendants that are acting strategically in order to preclude any broader review, they've now stipulated to temporary injunctions in order to prevent an injunction that might then get appealed and get broader relief from the higher courts. And the other point about all of this is, and this is another special feature of SB 8, which is that normally in Texas law, Texas has a declaratory judgment act that allows citizens to sue the state of Texas or the state agency under the Texas Declaratory Judgment Act to get that broader relief. And in SB 8 and Section 171.211, SB 8 overrides the State Declaratory Judgment Act and reasserts sovereign immunity to prevent exactly that kind of lawsuit against the state to seek broader review in state courts. On the concern about post-viability abortions, I don't think that that's a concern for the court, partly because the petitioners do not provide post-viability abortions, and under this court's precedent in Whole Women's Health, that doesn't preclude a statute from being declared facially unconstitutional. So I don't think that that's a concern that the court needs to deal with. But at the end of the day, what the state of Texas and what my friends on the other side are saying is that clinics should just violate the law. They should go out there, they should go about business as usual, and subject themselves to the risk that they will be forced to close their doors. But I want to make clear, Your Honors, that this is not just a decision for clinics to make. Even if clinics and health centers decided to violate the law, they may not find physicians, nurses, ultrasound technicians, staff members willing to work behind the desk because this law targets all of them. Every single person would have to make the decision, am I willing to subject myself to the risk that of $10,000 or more, it's a minimum liability per abortion, plus the risk that I'm going to be hailed into suits all across the state, and I'm going to have my ability to have an attorney taken away from me because my attorney may have to pay attorney's fees. Every single person. And that's exactly what this court addressed in Ex parte Young. Ex parte Young, and the reason the principles underlying Ex parte Young support relief here, is one of the things that it said is that the railroad may not be able to find an agent or an employee even willing to violate the law to generate a test case. And so, Your Honor, for all the reasons that we stated, we think the principles of Ex parte Young support relief here, and we ask that the district court's decision be affirmed.
Thank you, counsel. The case is submitted.
So what are your overall thoughts about the oral argument?
I think that's good. I think the rebuttal was very good, very concise, to the point. I mean, it's actually been a while, Kurt. It's actually, honestly, I was thinking when I was first listening to this, when's the last time I listened to I know I missed the beginning, but when have I listened to a oral argument through? Frankly, it's actually been a while, so it's kind of refreshing. I kind of enjoyed the experience.
Well, if you come to this channel, man, you get more of those things,
I love it, man. I love it. It's good because, it's a different level of, like you said, it's the highest level because these guys are thinking about the problems at the highest possible level. When you're looking at the trial level, it's like almost the reversed opposite of it, right? They're looking at a very, very low, very granular level in terms of the details. These guys are looking at, for precedent because they know that whatever they do is going to be examined by every single court, by every single attorney. They know that law tubers,
decades, centuries.
And now they probably know that law tubers are here grilling them on their.
Oh yes, I'm sure that I've somehow crossed their desk. If there's anyone at the Supreme Court who knows I exist, I'd be amazed. Also, incidentally, I'm available as a clerk on very short notice. Very short notice. Like my work, I'm licensed, I'm ready to go. Just let me know.
Yeah, that's my strategy. I had somebody call me last night when I was trying to go to bed, and then they're like, "Oh, do you want some work?" I'm like, "Yeah, sure, let's do it." I'm always available on short notice.
All right. So as I indicated, we have a decision on this already. So that's a nice little thing. So we can turn around and just read it. So we'll just read the syllabus.
Yeah, I
in
think
the
that's
interest
good.
of time. The
Which
syllabus
way,
is
Q?
prepared by the court as a summary, and so we'll just read what it has to say. So here's what the court has spoken. The court granted certiorari before judgment, and that in this case, that's a technical term. It means before a review by the Court of Appeals, is what that means. In this case, to determine whether the petitioners may pursue a pre-enforcement challenge to Texas Senate Bill 8, the Texas Heartbeat Act, a Texas statute enacted in 2021 that prohibits physicians from performing or inducing an abortion if the physician detects a fetal heartbeat, and that term is more defined in the statute itself.
Yep.
SB 8 does not allow state officials to bring criminal prosecutions or civil actions to enforce the law, but instead directs enforcement through private civil actions, accumulating in injunctions and statutory damage awards against those who perform or insist with prohibited abortions. Yep. Tracking language from Planned Parenthood versus Casey permits abortion providers to defeat any suit against them by showing, among other things, that holding them liable would place an undue burden on women seeking abortions. This is a affirmative defense that's available to those providers. The petitioners are abortion providers who sought pre-enforcement review of SB 8 in federal court based on allegations that SB 8 violates the federal Constitution. The petitioners sought injunction barring the following defendants from taking any action to enforce the statute: a state court judge, Austin Jackson, a state court clerk, Penny Clarkson. These people are just like representative. They can pick
pretty much everybody.
Doesn't matter.
Yeah.
Texas Attorney General Ken Paxton, Executive Director of Texas Medical Board Stephen Carlton, Executive Director of the Texas Board of Nursing Catherine Thomason, Executive Director of the Texas Board of Pharmacy Allison Benz, Executive Commissioner of the Texas Health and Human Services Commission Cecil Young, and a single private party, Mike Lee Dickinson, who I'm not exactly sure who that is, but whatever. The public officials defendants moved to dismiss the complaint, citing, among other things, the doctrine of sovereign immunity, which incidentally Texas also did that. They said we're not suable. You know, we're putting it to the absolute line possible. They definitely gave themselves all the sovereign immunity that's possible. Mr. Dickinson also moved to dismiss, claiming that petitioners lack standing to sue him. The district court denied these motions. The public official defendants filed an interlocutory appeal with the Fifth Circuit under collateral order doctrine, which allows immediate appellate review of an order denying sovereign immunity. The Fifth Circuit decided to entertain a second interlocutory appeal filed by Mr. Dickinson, given the overlap in issues between his appeal and the appeal filed by public officials. So, in the name of judicial efficiency, I suppose.
I love interlocutories. Those are just great issues.
The Fifth Circuit denied petitioners' request for an injunction barring the law's enforcement pending resolution of the merits of defendant's appeal, and instead issued an order staying proceedings in the district court until that time. The petitioners then filed a request for injunctive relief with this court, seeking emergency resolution of the application ahead of SB 8's approaching effective date. In the abbreviated time available for review, the court concluded that petitioners' filing failed to identify a basis in existing law that could justify disturbing the Fifth Circuit's decision to deny injunctive relief. The petitioners then filed another emergency request asking the court to grant certiorari before judgment to resolve defendant's appeal in the first instance, which the court granted. So, so they couldn't find an injunctive relief, and then so on the procedure, and then is there anything on the merits? It's affirmed in part and reversed in part, and therefore as to the merits. Justice Gorsuch announces the decision of the court and delivers the opinion acceptance to Part 2C, concluding pre-enforcement challenge to SB 8 under the federal constitution may proceed past the motion to dismiss stage against certain of the named defendants, but not others. Because the court grants certiorari before the judgment, the court effectively stands in the shoes of the Court of Appeals and refused defendants' appelling challenges that the district court denying the motion dismiss. That's perfectly fair. We're now just a Court of Appeals. Like any other Court of Appeals, we've now stepped in their shoes. Fine. As with any interlocutory appeal, because now they're interlocutory and appealing to us, the court's review is limited to the particular order under review and to any other ruling inextricably intertwined with or necessary to ensure meaningful review. So we're definitely trying to cabin this already.
Yep.
In this preliminary posture, the ultimate merits question, whether it's consistent with the Constitution, is not before us. Yeah, we're not deciding that one.
It's good. It's good they made that clear, though. They made that very, very clear.
Yeah, the court, which is absolutely legally correct, by the way, it is legally
Yes.
correct. If you got into the merits, you'd actually be very salty about it. The court, which wouldn't be the first time, but still, the court concludes that petitioners may pursue a pre-enforcement challenge against certain named defendants, but not others. Under the doctrine of sovereign immunity, named defendants Penny Clarkson, a state court clerk, and Austin Jackson, a state court judge, should be dismissed. The petitioners have explained that they hope to certify a class and request an order enjoining all state court clerks from docketing SB8 cases and all state court judges from hearing them. The difficulty with this theory of relief is that states are generally immune from suits under the terms of the 11th Amendment or the doctrine of sovereign immunity, while this court in Ex parte Young did recognize a narrow exception allowing an action to prevent state officials from enforcing state laws that are contrary to federal law. That exception is grounded in traditional equity practice. And as Ex parte Young itself explained, the traditional exception does not normally permit federal courts to issue injunctions against state court judges or clerks. The traditional remedy against such actors has been some sort of appeal, not ex ante, that means before, action before, injunctions, preventing the court from hearing the cases. So post, not ex ante. As stated in Ex parte Young, an injunction against the state court or its machinery, which would undoubtedly include the court clerks, would be a violation of the entire scheme of our government. The petitioner's clerk and court theory thus fails under Ex parte Young. Fair. It fails for the additional reason that no Article 3 case or controversy between adverse litigants exists between petitioners who challenge SB8 and either the state court clerks who may docket the disputes against petitioners or the state court judges who decide them. Under Muskrat, which is a case I've discussed in some limited ability. Further, as to remedy, Article 3 does not confer upon federal judges the power to supervise governmental operations of states, right? Separate sovereigns and all that. The petitioners offer no meaningful limiting principle, and those are definitely words you want running through your head. If you're ever on the Supreme Court, please keep the idea of limiting principles first and foremost in your head. That's an important thing. That would apply if federal judges could enjoin state court clerk judges and clerks from entertaining these disputes. And if state court judges and clerks qualify as adverse litigants, which seems absurd for Article 3 purposes in the present case, then why wouldn't they? Many more questions than answers would present themselves if they journeyed the way of petitioner's theory. It's like, yeah, they're not an adverse party to you. That doesn't really make sense. Texas Attorney General Paxton should be dismissed. The petitioners seek to enjoin him from enforcing SB8, which the petitioners suggest would automatically bind any private party interested in pursuing the suit. The petitioners have not identified any enforcement authority the Attorney General possesses in connection with SB8 that a federal court might enjoin him from exercising. The petitioners point to a state statute that says the Attorney General may institute an action for a civil penalty of $1,000 for violations of this subtitle or rule adopted by the Texas Medical Board. But the qualification this subtitle limits the Attorney General's actions to authority in the Texas Occupational Code, and it's not within that subtitle. Yeah, that would be exactly what that means. If it says you can bring something for that subtitle, it means, for that subtitle, not other things. Nor have petitioners identified for us any rule or order adopted by Texas Medical Board. The Attorney General might enforce against them. And even if the Attorney General did have some enforcement power under SB8 that could be enjoined, the petitioners have identified no authority that might allow a federal court to parlay any defendant's enforcement authority into an injunction against any and all unnamed private parties who might seek to bring the suits. Consistent with historical practice, a court exercising equitable authority may enjoin named defendants from taking unlawful actions. But under traditional equitable principles, no court may enjoin the world at large or purport to enjoin the laws themselves. So yeah, as is typical, we have to find actual named people we can enjoin. And then the logic of that may read into other people, but we still need to find the people in the first instance. The petitioners named other defendants, Stephen Carlton, Catherine Thomas, Allison Benz, and Cecil Young, each of whom is an executive licensing official who may or must take enforcement actions against petitioners if petitioners violate terms of the Health and Safety Code, including SB8. 8 members of the court hold that sovereign immunity does not bar a pre-enforcement challenge to SB8 against those officials. So they think that they might to the extent they violate SB 8, that those people would have the ability to punish them. Now, I
These
think
specific licensing officials.
Yes, these specific licensing officials. Now, I think the answer here for these licensing officials is actually fairly easy. I think, I mean, at least from my mind, and I don't know why you wouldn't do it. It's just be like, yeah, okay, SB 8, whatever authority we might have otherwise, SB 8 specifically says we don't have authority. So it specifically denies this authority. So we can't, we disclaim for ourselves the ability to regulate or discipline any official, any person for anything under SB 8. So if you violate the law and under SB 8, we have no power to discipline you or bring you before any medical tribunal, or
they're not going to pull your
board.
license. They're not.
Yeah,
gonna,
we can't touch you.
Right.
That seems
right.
like the simple answer. It's like, yeah, we can't touch you. Which seems like what the law is exactly contemplating anyway.
Right.
So that should be relatively easy, I would think. The sole private defendant, Mr. Dickinson, should be dismissed. Given petitioners do not contest Mr. Dickinson's sworn declaration that he has no intention filing a suit, they cannot trace it to him. The court holds petitioners may bring pre-enforcement challenge in federal court as a one means test of SB 8's compliance with the federal constitution. Other pre-enforcement challenges are possible too. One such case is ongoing in state court where the plaintiffs have raised both state and federal challenges against SB 8. Yeah, there is at least one doctor who actually has an actual suit that actually exists. So that might, provides him some avenue. Any individual sued under SB 8 may raise state and federal constitutional arguments in his or her defense without limitation. Whatever a state statute may or may not say about defense, applicable federal constitutional defenses always stand available when properly asserted. See the United States Constitution. It's always good. Many federal constitutional rights are, as a practical matter, asserted typically as defense to state law claims, not in federal pre-enforcement claims. Other viable avenues to contest the law's compliance with the federal constitution may also be possible, and the court does not prejudge this possibility. So, yeah, so the long and short of it is they say that you can sue these regulatory officials under the state licensing scheme, but if I'm the state of Texas, it seems like a no-brainer. We confess judgment, call it a day. It's like, okay, yeah, we have no intention of bringing any disciplinary or other regulatory action for any doctor who violates SB 8. We're not going to do it. It's SB 8 itself strips authority away. We read that. Stripping our authority away, we concede the case. Let's go away. That seems like the answer to me, right?
And that kind of eliminates that avenue of attack on the licensing officials. We're like, we're just not going to do it. We instantly say, yeah, we have no power. We concede the point. And do you want to waste your money paying for your counsel? Because this is what always goes through my mind. This is the corporate counsel side. I'm just thinking of like all the dollars to pay lawyers to file useless lawsuits like that do nothing procedurally. And it's like, yeah, don't waste your time and money suing us. Go sue somebody else. Go elsewhere. Right? Resolve the substance of the issue. Because like the procedure, this is like a procedural attack, and I just feel like it's kind of impotent in a way. Like you said, you can just diffuse it by saying, yeah, we're not going to, pull some doctor's medical license. We're not going to throw a nurse out. We're not going to decertify them. Like, we're not going to do that. So go away.
Yeah, we're happy. We're happy to enter.
But theoretically,
we're happy to enter a consent judgment right now. Let's go.
We now have precedent for suing licensed officials throughout the United States for similar things, right? For example,
well, to the extent they would be disciplining them for things that are, to the extent they would be, I think you're there because then you'd just be in enforcement. So if you're gonna try to revoke the license of a doctor who's performing a lawful abortion, then I think you would have this problem. I don't see any problem bringing a lawsuit against the disciplinary board for that one.
Oh, I'm trying to think about converting this because I'm going to convert this to other rights. I'm like, okay, let's make this a 2A right. Like, what licensing official are they would this come up with in a separate state? Because now this is an issue because this is now case law. So, it's like what officials are they gonna, talk about suing?
Well, I can think of one official in particular who we might bring a lawsuit against, a guy named Bruin, and NYSRPA versus Bruin, who is a state official who isn't granting us a license for our concealed carry permit. That would be a good example.
But that's the opposite. I mean, in this case, it might be something like people trying to sue to dampen Second Amendment rights. So it's saying, because you, permitted the sales of AR-15s, you're the licensure guy who, licensed the gun shop. we're going to sue you to enjoin. I don't know. It's just it's really weird. Like I'm trying to flip that hypo and it's not clicking.
I suppose if there's some state official who is
because the whole theory is right. The whole theory is to make it more simple, right? So even I can understand it. Is that New York and California are going to pass something similar to this to allow people to sue for people bothered by guns, right? So they're going to give private citizens a right of action to sue individuals who have done something with guns that they're not happy about, right?
Oh yeah.
So then, what I'm trying to think of the licensing official. I guess it would be like depending on what the person.
Yeah, but I don't think the logic quite works, because in this hypothetical universe, this would be like the state of California just claiming all power for its state officials to regulate anything related to guns, but we're going to empower all the private people to bring the lawsuit for us. Do you for once? I mean, yeah, it's like, I guess, and then in that hypothetical, then California be like, yeah, you can't sue us because we're not going to do anything because we have no power. We've taken power away from ourselves. This also reminds me of NYSRPA the first time around, where they mooted the whole question by running to Albany as fast as they can. Say, can you please pass a law that strips New York City of all of its power, and that we have no power to do this, so that we can't.
Yeah, I see that super chat saying they let them sue firearms dealers where the gun was used in a shooting. That's the sort of type of thing I'm thinking about, is like these, opening causes of actions for people, against.
Yeah, well, but for the Lawful Commerce Act, they would do and have done, and are still doing in the Remington Sandy Hook thing, which doesn't make sense to my mind, but
yeah,
I mean, the Supreme Court of Massachusetts said it's a viable cause of action. I don't know if the federal court ever took a shot at that, because I'm not seeing the negligent entrustment theory from saying get your man card by buying our firearm. How's that entrustment?
That was literally the case. That's literally the fact at issue.
I don't think I'm straw manning it. I think that is the issue, that the firearm, because the firearm was, some are AR-15, and it was sold by whomever, and their whole part of their ads was literally, get your man card, with the rifle as part of their ads. So they're trying to argue negligent entrustment by the firearms manufacturer for running these ads that make their products really, really desirable among people who might use them for no, that doesn't work. But the Supreme Court of Massachusetts disagrees with me. So, who am I to disagree with the Supreme Court of Massachusetts?
It's not like they have a particular slant.
Yeah. So that case is still ongoing. Remington is getting their ass sued.
Didn't they declare bankruptcy? They filed for bankruptcy?
Maybe. I don't remember. It's possible.
Yeah, I think I'm seeing that. I pulled it up, and that was really interesting. I think they filed for Chapter 11 in 2018 and last year. So,
but you try to get around the lawsuit, all that can work too.
Mm-hmm.
The New York State the bankruptcy court didn't let the NRA get away with that.
Yeah, but the NRA had other issues too. I think organizations.
The NRA makes me sad. I was a patron member, and Wayne LaPierre is not great for the organization. Mm-hmm. Maybe he was great at one time, but not so much anymore. Join the Second Amendment Foundation. I'm a member of the Second Amendment Foundation for life, and join Gun Owners of America. They're good. I don't know much about the one that was brought up, Firearms Policy Coalition. I don't know much about them. Do you know much about the Firearms Policy Coalition?
I don't know. And that was actually one of the questions that I think I initially posed on my channel before I met all you guys was where are we going after the NRA, right? And I think that's good. Second Amendment Foundation is a good place to start, right?
I'll have to look into the FPC, because maybe they're the organization for me. Do they need a lawyer? If the FPC is watching this and they need a lawyer, I am also available. I'm looking for new work. And
should I take you pro bono?
No, you're definitely going to have to pay me. You definitely got to pay me.
I think it's out there. I guess the thing is none of them have the name recognition yet. So that's the real issue with those organizations. Is they just don't have the name recognition. Yeah. And they're going to take a while to build it up. And also, when you're splintering into different organizations, it's definitely it's going to be more challenging for people to give them sufficient funds to be able to do the same level of work that the
FPC files a lot of lawsuits. That's cool. A Second
And a
Amendment
regular.
Foundation was known for, or is at least known to me for that. Second Amendment
Yeah.
Foundation for filing lawsuits. I don't know about the FPC, but if they're like that, that's cool. Well, anyways, I know that you're running low on time, and I do thank you for joining me.
This is really fun, Kurt. I didn't
looking
realize
forward-
how fun this is.
Yeah, I've been looking forward to doing something with you, and we definitely have to do more of this stuff. It's long overdue.
Yes.
But why don't you go ahead and plug all the things? Tell us where we can find you on
Yes.
the interwebs.
Yes, and Uncivil, I need to have you on my channel too, because it goes both ways. So if you want to find me, guys, Twitter at The Legal Mindset, not Legal Mindset. Don't make the same mistake that Viva Fry did. So The Legal Mindset on Twitter, Legal Mindset on YouTube. My locals is legalmindset.locals.com. Either later today or tomorrow, I'll be posting my weekly locals review video. So everything that's posted on my locals, literally from the last week, I don't care how long it takes me an hour, 2 hours. I go through every single article. I give my commentary on it. I give my opinion on it. The last one took me almost an hour. This one, there's way more information. It might take me 2 hours, but that's what I do on legalmindset.locals.com. Have a great community there. So come and join that. Give it a look. Kurt, thank you so much for having me, man. It's been really fun.
Hey, no problem, man. Yeah, make sure to check them out on locals. You can also check me out on locals, something I'm looking to develop on civillaw.locals.com, and we'll try to help fight the YouTubes who are continuing to censor me because of reasons and things.
And this is a fight we both are fighting, Kurt, and we're all fighting, which is why it's important you guys support. It's important you guys get here in the chat, you super chat, join the communities, because they're fighting us, they're demonetizing us, and sometimes it's on stuff that we have no control over, that we think is just objective reporting. And a lot of times you'll be objectively reporting on something, and because YouTube has deemed that a topic that is a no topic, it's a topic you can't talk about, it's too controversial, they demonetize you, they give you a warning, they give you a strike. It's bonkers. And only through coming together and working together are we able to get this thing going. We're able to fight for each other. We're able to, create a Twitter storm adding Team YouTube and telling them they are wrong. And so far it's listening, but a rising tide rises all boats. There's room in this space for everybody. And Uncivil Law is a very important member of the LawTube community. So I really
Thank you
enjoy
very
him
much.
being around.
I've been on Uncivil Law. My guest has been Legal Mindset. Everyone, has been a lot of fun. Remember to subscribe to the channel, hit the like, all the YouTube things, hit the bell. Until later, my friends, I hope all is well. Cheers and goodbye.
See ya.